In the courtroom, it's a circus. Only got the lions, prosecutors crooked, messy and frying. Innocent rappers, the tears like diamonds. Truth gets twisted, just like the Mayans. Panel keeps the real, drug knowledge bombs. Corruption on blast like Vietnam songs. Free the innocent, they commit the crimes. Justice served hot, rhythm and rhyme. Show and survive, justice goes live. Spotlight on the truth, we cut through the lies. Corrupt gotta run, we see through the skies. For the innocent rappers, we rise. We rise.
Heyo, folks, it is Friday, and it is time for Friday panel show. And the invitations are out and accepted by a bunch of the regulars. There will be a new person who you haven't seen here before. Well, two people actually, and I already told the rest of the panel that the first guest, which is a surprise guest, is someone I needed maybe the first 20 minutes with alone, because this person do not follow this case at all. Well, he heard about it, because who haven't, but the specifics are completely new to him. And I'm going to present him by showing you guys. I should have prepared this. Yay, we are all professionals. By showing what he actually did or does. And so this is him. Oral argument of cost of incarceration before the Florida's 5th District Court of Appeals. So let's play a few minutes so you get a hang of who he is, what level he works at, and hopefully that will give you some knowledge on what we're dealing with here.
And for the record, this is the second case on our oral argument calendar, Self-Conor Wells versus State of Florida. Is the appellant prepared to move forward?
We are, Your Honor.
Please proceed. Before you do, how much time would you like for rebuttal?
Well, in deference to my honorable colleague, I'd like to split it half and half, because I know he's going to put the fire on me, so I'd like to have enough reserved time for rebuttal.
Okay, so that would be 10 minutes?
If I get 20, that'll be 10. Thank you, Your Honor.
Thank you. Please proceed.
Yes, Steve Cosby representing Mr. Wells. And this case is Mr. Wells was put in prison for a series of felonies. He was then had a tail end of probation. And then one of the conditions of probation was that he not dress up for Halloween in a costume that appeals to children. And then also another provision was he had a 10 p.m. curfew. He was found to be violated for those two violations. And for that, he received 22 years in prison, as well as a $400,000 cost of incarceration. I'd prefer to focus on point 3, which is the constitutionality of the cost of incarceration for the purposes of oral argument. The cost of incarceration it has not been tested in Florida constitutionally.
Before you get there, counsel, and we can certainly get to that in a minute, but as to the point about the violation of probation, did I hear you say, because I don't necessarily see this in the order, probation, that there was a prohibition on him dressing up at Halloween. That's not the way I read that provision of the order, but maybe I'm mistaken.
No, actually, you're absolutely correct. And one of the questions here is, do we read this order carefully as lawyers and strictly as a probationary order, or do we read it sort of loosely and say, well, it's just a Halloween costume and whatever it is? I would expect this court and law generally to be very strict with the reading of the probationary order. And if you read that, it lists a number of costumes that are not allowed. For example, Santa Claus, Easter, and then in the Halloween context, it's basically all of these things. The one, in order for him to be violated, has to show that it appeals to children. And then there's also an additional modification. If you read it carefully, it says, and passing out candy and Halloween type activities.
Well, and I'm looking at 44B. This is
All right. Let's bring him on, and he might explain what this case is, and then move on to the young thug trial and his opinion of the development this week. Everybody, I want to introduce you to a phenomenal lawyer. He is death penalty certified appellate attorney, and he is my friend, Mr. Gosney. Welcome to the show.
Good to see you, man. I'm back, baby. Yeah, well, thank you for inviting me on. This is my first I did have a little hello back to Joe stream, but he had a big panel and it was basically a thing. But you're my first, this is going to be like me commentating on stuff, and I really appreciate the invite. We'll see how long I can go, because one of the reasons I've been streaming is because I've been learning a new practice of law, which is civil, and I'm just worn out, and so I don't have the energy to give my best. And when I'm on, I want to give my best. So you were asking about this particular case. Well, this is a fascinating case. Yeah. So my client, Mr. Wells, was on probation, and he was not supposed to dress up in costumes that appealed to children. Okay. He was working, and his curfew was till 10 p.m. at night. Now, he was working at Denny's on Halloween, and he dressed up as a devil to get extra tips at Denny's and worked late to 10:30 at night. Now, the question, so he had 2 probation violations, one of which was dressing up in a costume that appeals to children. Well, the devil costume, there was no photograph and there was no testimony that the costume appealed to children. It was just a devil costume that he had made, and there was no testimony in the record. So he did not violate that order of probation. Now, he was 30 minutes late because in his curfew. So because he said, if you leave here, then you will be fired. And so he had to choose between staying and cleaning up, he was the last employee, or getting fired. And if he got fired, then he's in violation of probation too. So he stayed a half hour late on his work. He's working, which is great for a felon, right? And it's hard for a felon to find a good job. So for those 2 violations, the court in Citrus County, Florida, sentenced Mr. Wells to 22 years in prison and gave him a $400,000 cost of incarceration. So now on this oral argument, I was challenging both the violations and the cost of incarceration. Okay. Now you will know that I won on the costume issue. So the court came down and said he did not violate on the costume issue. So that was wrong. But he did violate on the curfew issue. Therefore, the 22-year in prison, $500,000 or $400,000 cost of incarceration stood. Well, because of that, and this has been a big issue in Florida for me, one of my pet projects has been to challenge this cost of incarceration, because it's basically so burdensome. And if you calculate it out, and it's in the brief, if you calculate it out, this guy here, Mr. Wells, when he gets out of prison, that $400,000 fine will exceed his lifetime expected earnings. So I'm arguing in the brief and to the court here and to the United States Supreme Court, for which this issue is pending, I'm arguing that $400,000 cost of incarceration is violative of the constitutional prohibition against excessive fines. And if it is a fine, and it is excessive, because for a fine that exceeds your lifetime expected earnings is excessive to me. And then the question is, and so the question before the United States Supreme Court is whether or not the excessive fines clause of the U.S. Constitution applies to costs of incarceration schedules. And that has United statewide impact because there's all these costs of incarceration. So you've just got you got the thing. So this is pending, but they have not accepted cert, but they have ordered the state to respond. The state did respond, and then I responded, and it's passed around for conference. So it is pending before the United States Supreme Court.
Mm-hmm. So we might, once they decide, hear you in the United States Supreme Court.
Well, I'm not with the public defender's office anymore, so probably not. I don't know but what happens if cert gets granted by the U.S. Supreme Court? I actually was working with a nonprofit up in D.C. that is interested in this case. Because so I would expect that if it goes to the U.S. Supreme Court, that they'll take over the case. And I have no ego involved in any of my cases. I mean, I'm in it for the clients and for the people of Florida, and I want to see justice done. It's just unjust that we destroy people's lives. We basically make it impossible for people who go to prison to ever lead any kind of productive life. And that's anti-American as far as I'm concerned.
Okay, that was a great introduction, and I hope that it succeeds, because I am of the same opinion. Now we do over here, over this side of the pond, we don't have that at all. The people have to pay to be in prison, so we don't have that. But we still have the usual stigma of former prisoners trying to get work, and which is sometimes in violation of their probation, which some employers use and say, you have to work, here's $2 an hour, and don't complain, because then you're fired and back in prison. And so that's an issue over here as well.
Yeah, and it's real tough, because his probation violation was he was working too hard. He violated his curfew. He worked a half hour late. The probation office basically wanted to give him a more strict form of probation, but the judge over in Citrus County gave him 22 years in prison. It's insane, very vindictive, and these are people with lives, and it's just a shame. Can I make a couple little shout outs? First of all, Excited Utterance is here. I want to say hi to Slidey Pie, and I want to send out my best wishes of all to Fiery Red Podcast, who is still fighting cancer, and who is kind of one of the things. He's like a beacon of hope, along with a lot of my internet friends who have been praying for me and been very kind and sent their good wishes. And it's helped me quite a bit, because I was very low and I've been working hard to get out of that hole. And so I want to thank everybody, but especially those people, and say hi to Fiery Casper. I see all you chatters, don't worry. But it's hard to say hi to everybody, but I wanted to point out those people especially.
Yeah. All right, now in for the subject matter at hand, the Young Thug RICO trial. And we had some interesting development this week, and Mr. Gosney has basically no idea what it's about, but I wanted his fresh opinion, because there's so many of us.
I'll say that I know, first of all, I watched it when this was like many moons ago.
Yeah.
Back when it kind of, there was something that happened and it hit the news and everybody covered something. But the thing is that this should have been a mistrial ages ago. Why this trial keeps going, I have no idea. Now, I haven't followed it since then. I've been kind of off the radar. So I'm sure there's a lot of good stuff that I'm not aware of. So I kind of have a familiarity. The prosecutor is out of control. She's got too many defendants. She's charged it too broadly, and it should have been mistrial long ago. That's what I know.
Yeah. Okay, but let's start with this all the way back to day 69, no pun intended. And this is cross-examination of Detective or Sergeant former Gaither, who has Mr. Shard. This cross-examination. And this is about some missing reports. So let's listen here.
Road to retrieve surveillance.
I did.
Was that in relation to the investigation of the January 10th, 2015 murder case?
Correct.
Okay. Surely, as you were working a murder case, you would have written a report about your efforts to obtain this surveillance, correct?
Not necessarily, no.
So did you write a report or did you not write a report about going to the McDonald's on Old Hateville and Cleveland Avenue in search of surveillance?
There was nothing to write, sir.
So you did not write a report?
There was nothing to write, sir.
Okay, so now I'm going to ask you a question. I'm going to ask you for an answer. Did you write a report?
Your Honor, I object. Asking the answer.
I sustain the
I haven't
objection.
received an answer, Your
I
Honor.
sustain the objection.
Okay. What day did you go to the McDonald's to obtain this surveillance?
It's the day after I spoke with a witness that gave me the information. I believe that day was January the 26th, I believe, the 26th or the 28th, somewhere in that range.
Okay. 26th to 28th. And do you or anyone else that you know of have a report reflecting that you went on the 26th or 28th?
Objection. Ask and answer.
Sustained.
Okay. Who did you speak to at the McDonald's? What was their name?
The young lady that was working the counter,
Yes.
she did not give me her name. She gave me her general manager's name and phone number, and that information was passed along to Investigator Thorpe.
And what was the name?
I don't have it. I gave it to Investigator Thorpe. sir.
What was the phone number?
I don't have any information from the McDonald's. It was passed along to Investigator Thorpe.
I have no further questions. Thank you.
All right, sir.
Now, the lack of reports have been continuous with Detective Gaither. This is an example of it, that she, even though she received information, passed it on, she didn't write an individual report about this specific event, about trying to obtain surveillance footage from the local McDonald's. On top of this, she left the Atlanta Police Department in 2020, after 19 years. For some odd reason, she didn't go the full 20 for full pension. And she put all her reports, everything she's done, everything in a file cabinet. And the argument from the prosecution on day 69 was that these reports, they can't find them, and the digital copies were lost in a 2018 hack event, which affected the entirety of Fulton County Public Prosecution's Office. So since day 69 and before that, basically no reports. Now let's go up to day 140.
I'm starting to anticipate something. I'm starting to feel like I kind of get what's going to happen here, but let's see it unfold before our eyes.
Yeah, and this is day 140. Nobody has told. Well, let's just watch what happened here.
Let's watch and enjoy and let it sink in.
I know off the top of my head, no.
Would seeing, first of all, did you keep a file for that case?
The kidnapping case?
Not the
What?
kidnapping case, but for the Browns Mill Road shooting case?
I did.
And did you have that file after you left the Atlanta Police Department?
No.
What did you do with that file?
I left it with the Atlanta Police Department in a file cabinet.
In a file cabinet?
Yes, ma'am.
Describe what that file looked like, if you can, to the jury.
It's approximately what, 7, 8 inches thick. It was reddish brown file folder binder. Had clips in it, a bunch of paperwork.
Did you look at with the state any such file before coming here right now?
Did I look at it? Yes.
Okay. And did you recognize that to be the file that
Yes.
you kept? Okay. Which showing you.
Wait a second now. All right, so I got a lot of questions here.
Mhm.
I will say that the asked and answered objections from the prosecutor to me were cover-up objections. I'll bet you they knew that such a thing existed, and they wanted to cut it off so that they'd have maximum wiggle room, so that when they produce it at a later date, then they would be able to say, oh, but they didn't ask the specific question, right? So to me, the early objections were disingenuous. Why would you object to that specific question? Asked and answered. She says she didn't have anything. It's not objectionable. The question wouldn't hurt anything. It just delays the proceeding. He's trying to nail her down, and they're protecting the witness from answering. Now they're late disclosing. To me, those objections mean they knew about it on day 69. That would be my first that's intuition, and I've got an intuition, and I can't prove it, and I can't say, but this is just commentator shooting from the hip intuition. I would say that the prosecutor knew that report existed on day 69. What say you, Nick?
Let's continue playing.
Okay.
But first of all, remember, she asked, did you see this file before we walked in? And she said, yes. Is this the file that
And then
you
the next
left
question
at-
is,
Yeah.
when was this disclosed to the defense? When was it discovered? Because somewhere, let's assume that they weren't operating in bad faith in day 69.
Yeah.
When did they discover the file? When did the witness then say, oh, I have this file back in the file cabinet? Then they point to it. And when was it disclosed to the defense? These are basically, in Florida, we call it Richardson violations, which is, but let's see how it unfolds here.
Yeah, but I want you to just remember how she asked the question here was, did I show you a file? She answered yes. Is this the file that you had back then? And she says yes. That becomes important later.
A portion of that file, refresh your memory as to what phone number that you had.
Your Honor, may we approach?
Yeah, that's right. Yeah, we have some issues.
Your
here,
Your
okay,
Honor, may we approach? These lawyers are excellent. They, within just a few questions, because Prosecutor Love has had quite a history of trying to sneak. Now, there's a standing order from this judge that every piece of evidence attached to every witness must be disclosed to the defense before the witness takes the stand. The Friday before, if it's the next week at the latest. And now they're asked to approach.
But orders are toothless if the judge doesn't enforce them. This should have been a mistrial a long time ago. It should be a mistrial on this issue alone. And every time I encounter this trial, I see bad prosecution after bad prosecution. I see mistrial after mistrial. And I don't know. I just think that, and every one of them, if I was a judge, I would have granted every one of them. So why this thing keeps continuing and wasting all these defense lawyers' times and all these jurors' time and everybody's time, I don't know. I don't understand why the judge doesn't have the, cojones to go ahead and just grant the mistrial.
Yeah. Do you know how, just for shits and giggles, guess how many motions for mistrial there has been in this trial so far?
Boy, that's a tough question. Well, I remember one day on a trial I had, it was a 1-day jury trial. I had 4 mistrial motions in one day. But I don't know. That was crazy. I don't know, maybe 20 or 30. Let's go 30.
45.
45.
Which is the most in US history in one trial, apparently. 45 motions of mistrial. Now, they took a break. She is sending off the jury for an early lunch, the judge.
But now I see this a new judge. The last I saw this
one.
Last I saw this case, the other judge was on there. So he finally recused himself, which he should have done.
No, he was recused. He didn't
Okay.
recuse himself.
Good. Well, that should. But it's over. I mean, this case is, it's horrible.
Yeah.
This is
But
just not justice.
Let's listen to what happens.
Embarrassing.
An early and long lunch.
All right, for jury.
Before we ask Investigator Gaither any questions, I would ask the court to inquire of the state when they received this file and how they received this file, because we're completely in the blind.
Okay.
We went over to the Atlanta Police Department,
When?
obviously before.
Is your mic on?
I'm using a mosquito mic, but yeah.
Just before we served, I think we called it complete case files from Operation Planners incident. This is where we got this one,
A bit spoiler. They have had the file for all the time, but it was not attributed to Gaither. So it was in discovery back in 2022 amongst a plethora of different files, but this one wasn't named.
Was it provided to this? Was it provided to the defense?
It was in they handed it over amongst 7 terabytes of other documents. So it was buried in discovery. And now they claim, we didn't realize it was Gaither's.
I'm just trying to get it clear here.
Yeah. So it was in discovery.
Well, now I want to see the document, because does the document have Gaither's say? But she answered on the stand that she wrote no report.
Yeah.
So she's committed perjury in front of the court. Oh,
Yeah.
Sick. Yeah, I mean, and the thing
other
is
ones that were included in that discovery tranche from the Atlanta Police Department. That's where they came from. The one titled Complete Case Files of 2015 Operation Planners. If the court will allow me, I will ask our legal assistants to give me the date that we served the file called Complete Case Files of Operation Planners.
Okay, and so the contents of that file were served whenever that was?
Yes.
All right, what led you to suddenly ask Detective Gaither if this was her file?
As I was looking through for a particular number, I was trying to find both that photograph where Mr. Zachary had signed 8515 Nard on the Brownsville Road photograph. So I was looking for that. And I was just looking through everything that we had. And in looking through it, because I knew I'd seen it somewhere, I found it in this particular file folder. And looking at it, I initially I'll show the court what I was about to show.
Well, why don't you put it back together And I know we're asking you to do several things at once. So how about put it back together and then you can finish your answer.
Hold this. Planner's complete case file. That's what this is.
And now they remember, and they are talking into the microphone. Now, this is interesting. Let's skip ahead because I want to show you.
Finish your answer as to why this suddenly.
Yeah. Now, through Gaither's recollection, oh, it was a red brownish. Well, if she saw it before she walked on the stand, yeah, of course she would testify to that. Then there is some development. This file, which she on the stand said, yes, this is her file, actually says it's signed by her, but it also says copy. That is sent to the district attorney's office, that then that district attorney back in 2016 something used as material. So it's not her file. It is parts of her file combined with notes from somebody else and other information that it's not from Detective Gaither. So when she identified that as her file, you're completely correct, Steve.
See, here's part of the problem with what's going on here. You know, it's like, you know, there's a famous Clint Eastwood line that a man's got to know his limitations, right? Clearly, this prosecutor's office is not capable of conducting an organized trial this large and this complex. They should recognize, they should have enough self-awareness to say, we are not competent here. We are limited. We have limited resources, limited abilities. I'll tell you what we need to do is break this into smaller component parts and do little trials rather than one justice to solve them, one trial to solve it all. Break it into smaller parts. Yeah. Keep your trial lean and mean. Try one case at a time. This clearly is way over their heads' ability to do. They're not organized. They're not under control. They don't know what's going on. So to me, this is all error on the prosecution by shooting over their pay grade. They don't have the competent people to do what they're supposed to be doing here.
Yeah,
starting with the top.
Yeah, and as you heard Prosecutor Love say, she was searching for a certain type of information. Well, the prosecution said they were ready for trial in December of 2022. How is it that the weekend before or week before, she's still searching for stuff to ask a witness they have had planned for over a year?
Well, and if it was one error in a long trial, and this is the first time this gone up, it would be excusable, right? Mm-hmm. It would be okay, you know, we made a mistake here. Everybody makes mistakes. But when it's, how many you said, how many mistrial motions? I mean, it is baked in the cake that this prosecutor is unorganized, over their head, acting in bad faith, presenting perjured testimony, playing games that are contrary to justice, and it should have been thrown out a long time ago. I remember last time I was on, which I don't know what day that was, but the other judge was still on, and I think it was the contempt motion against the. I think that's what it was that. Yeah, it was like that one witness that was mistrial all day. Yeah. But I don't know. I mean, I don't know what's going on in Atlanta or Georgia generally, but people in Atlanta should be ashamed of their DA's office.
Yeah. Some time ago, I believe it was Doug Weinstein, who had a motion for quick prosecution, more or less asking the judge to put a time limit. Now, a judge can't tell the prosecution how to run their case, but they do have the authority to put time limits. And the DA's office were so offended by this. It was.
They should look in the mirror. I mean, who do they
Yeah.
think they are? These are representatives of the people. These are representatives of the people. Their job is to uphold the law. It's not a glory ego trip on parading around and showing in front of the cameras what a brilliant attorney you are by talking everybody's ears off and boring the jury and trampling the rights of defendants.
Okay, it was.
That's not the job of the prosecution. The prosecution is supposed to uphold the law.
Yeah, but when it comes to prosecutor love, I've covered another case involving prosecutor love, the Shane Kendall case, and where she lied to. It was a hearing about competency. Shane Kendall, severe mental illnesses and issues. And she lied and managed to convince. I don't know how Georgia can have that. It was a jury who decided competency.
You know, the first prosecutor lie, there was an obvious lie. I'd been to a mistrial. You know, as soon as you tolerate number one, number two is much easier to say, oh, well, we already gave a pass on this one. And now what lie we're on? Probably lie 45, right? I mean, there can be no tolerance for the state's lying on a criminal. This is a citizen whose liberty is at risk. This is somebody who is a citizen of the United States who the state is seeking to put in a cage for the rest of their life, right? And we're going to allow the state to lie? No. That is not allowed. That is not what is. But as soon as you let, oh, well, we're going to let that little lie pass. It's okay because you're powerful or you're somebody who's important or you're a prosecutor or you've got some title or badge. We are drowning in lies in this country. And sadly, the prosecutors are leading the charge right here in Atlanta.
But more a person who has been waiting very patiently backstage, who can talk more about Ms. Love lying and have a history of doing so, is the attorney for Shane Kendall. Hello, Rachel Kaufman.
Hello. Happy Friday.
Happy Friday.
Stephen,
Rachel.
hearing you just like as an outsider looking in, and obviously Nick all the way across the sea, it's just incredibly validating because as a defense attorney practicing in Georgia, and in Fulton County mostly, I mean, what I think is it's so crazy to people who aren't here, but the judges permit just endless unethical behavior by prosecutors. Most of them have been prosecutors. There's really no neutral arbiter here. And at no time will Miss Love's behavior result in a mistrial or any form of consequence for her. So she keeps doing it. She's been doing this for 15 years. And I personally witnessed
this
in
is
several
the problem,
cases.
and a big problem. Wow.
Yeah. No, keep
in
going.
the United States,
please.
we have a major problem in the United States, and that is unchecked prosecutorial power. And George Soros has discovered this weakness within the American system, that prosecutors, there's no real check on prosecutorial power. And theoretically, it would be judges and the bar. But when you have judges that are former prosecutors, you have all these insider incestuous games going on, and you have a bar that, I mean, in Florida, I did an article a while back. I wrote an article on that, but I wrote an article on prosecutorial closing arguments that should be ethically done. And in Florida, we had 5 prosecutors disciplined for improper closing arguments in the last 30 years. That's one prosecutor disciplined every 5 years. So that is basically no sanction at all. And I mean, those sanctions were basically admonishments.
Yes, slaps on the wrist.
So basically, there is no prosecutorial check, and so you have unchecked power. And Lord Acton said, with absolute power comes absolute corruption, right? And that's what we're seeing play out before us. Now, I don't know. I mean, there's got to be a reform within the system, but this is a very much a weakness that's being exposed in the American system. And good defense attorneys like Rachel here and like this defense team here do everything they can. But if the judges don't go along with it, the appellate courts don't go along with it, you see railroad, you see injustice, the system will collapse. We cannot tolerate lies to infect our system, but this is what we see in these big cities.
One thing I want to say really quick, Stephen, about, because I was taking notes when you were chatting, about how Fulton clearly seems ill fit to be handling these complex RICO cases. Fascinatingly, Fani Willis hangs her hat on this prosecution that she did before she became the DA, where she was the head of a RICO case against Atlanta public school teachers that they accused of messing up Scantron so the school could get more grants. In her eye, and it took like months, and it was several defendants, and it ended up being a mess. And I don't think anybody in Atlanta thought that it was a success at all. Nobody even I don't think anyone got more than like a year in jail after all of it. But we can look at how so I don't know. So you do it once, it doesn't work. Why are you doing it again? I want to talk about the Trump case, because Fani Willis's office is also dragging on this RICO case from more than that affects an election. I mean, it really affects. If she went through the prosecution individually instead of needing to do this gigantic RICO case and take a year to do it, I mean, we'd at least have a jury look at the case for the truth and for the facts and do something about it, instead of having these felonies pending against the Republican candidate for president of the United States 4 years later. It's failure.
Well, and that's the thing, is you get these loci of power. You get these loci of power within big cities, and that's in clerks' offices and in you just need, like, I had the worst case of my entire life was, and we represented an actually innocent person, and that person got convicted, and it was because there was a corrupt prosecutor and there was a corrupt judge. And and if you have that combination, there's nothing a defense attorney can do. And I know that people don't understand how important these things are. I mean, the lies and the ethics, the lies and the lack of ethics that are infused in the system, which comes from the people, are really destroying the system from within. And I'm very saddened to see it, because I've experienced it firsthand on every side, and it just cannot be tolerated. These judges, maybe Rachel can enlighten us a little bit more about the judiciary and why the judiciary there is so reluctant to hold prosecutors to account.
I feel like it's the same reason that it's really difficult to hold police officers accountable. Sorry, my dogs are playing in the background. In Georgia, again,
police accountable. Police officers are accountable a lot more.
Well, a lot more, but it's still, they protect each other, and they're still protected. There's something about the pipeline from prosecutor to judge that I think has a lot to do with it. You have judge, especially in Fulton County. I can't really speak to, the United States at large, but I can tell you that, when you have a judge who's looking at what a prosecutor can do versus what they should do, they're in a position where they're looking at what a prosecutor is allowed to do before they get reversed, which I think, as you also know, Stephen and Nick, it takes a lot to get something reversed. It doesn't mean that it's the right thing to do. It's just what they knew that they could do when they were prosecutors. It's very dangerous.
Yeah.
They need neutrality training.
Yeah, from the outside looking in.
Do you have elected judges?
Both. We have elected, and then like if somebody retires or something midterm, the governor gets to appoint people. But I should say, there are some prosecutors. Like I really like Judge McAfee, who's on the Trump case. He's a former prosecutor in that office, but so is Paige Whitaker. She worked with Adrian Love, to be very clear. They worked in the same office for several years.
Yeah, and one thing looking from the outside and in, it seems to me in Georgia that the judges even though they know it's a clear violation, they punt it forward to the appeals court. Somehow, if they are scared of making the wrong decision, or if it is one of these re-election things that I don't want to let these guys go because then I won't be re-elected. And I mean, the first
such
responsibility
an
for any
abdication
judge should be
of
the Constitution and
such an
nothing
abdication
else.
of their oath and their responsibilities. And yeah, I mean, just
People are
follow the
scared.
law. You know, that's the thing. Once you get tied up in, when you get tied up in lies, it's an endless cycle of downward departure, is of downward spiral, right? If you just stick with the law and stick with the facts and stick with the truth and what's right, it's so much, all this stuff falls away. Once you allow that first prosecutorial lie to go flying by, number two is just as easy. It gets easier.
I've described it as being, I mean, as someone who's been there, watching this happen, it feels like you're in a riptide. Like you literally you're stuck and you're along for the ride and you're going down. That's it. Like fighting it. And that's what's hard is that as a defense attorney, at some point you're like, you want to make your record for an appeal, but you just get exhausted being pulled, everyone's pulling against you the entire time. It feels like you can't advocate or move. Yeah.
Having done appeals for 14 years, or I think it was 14 years I did appeals. And I'm a trial attorney, basically. I'm not a trial, but I got a diversion into criminal appeals. And doing criminal appeals, I remember my fellow appellate brethren in the office would say, why didn't they preserve that? Why didn't they object? Why didn't they do this? Why didn't they do that? Right. But of course, I came from the trial world. And it's like, I know, because when you're in trial, you're out there to win. You're looking to see, like, you're looking over to that jury and say, if I object, is the jury going to read into that? So there's reasons why you don't object. There's reasons, because you're not thinking about losing. You're thinking about winning, or you're thinking about convincing that jury or getting the best shot. There's a lot of that. And also, it's a whole different mindset. Preservation on appeal is a different, click. It's a different thing. And so a trial attorney doesn't necessarily think that way. And the requirements that the appellate courts put on defense attorneys are basically inhuman, because they expect perfection, not a human being who's actually trying to do a case and do it with all our flaws and all our limitations. And then you got judges up there. It's like one attorney at a time. I only let one attorney do one thing at a time. And so you're in there trying to do one thing, and then they're requiring you to do something else at simultaneously. It's impossible to do two things at once.
You're trying to advocate for your client in front of a jury while also being an appellate strategist.
It's impossible.
It's impossible.
It's a level of perfection that is no human can stand, but yet it's a way for the appellate courts to wash their hands of, well, the defense attorney screwed up and you're our scapegoat.
Yeah, I love when they consider things based on whether they're harmful or not, harmless error. I'm like, who are you to tell me whether it was harmful or not? Or who are you to tell me that a curative instruction to the jury actually cures the issue? There's never been studied by anybody, and it just drives me crazy. They just assume that telling a jury that they shouldn't have heard this somehow unrings the bell and works they call it curative.
Right.
Cures nothing.
Hey, Rachel, can you tell me more about Rachel? Because you're brilliant. I love what you're saying. You're right on the task.
Thank you.
Tell me a little bit about yourself.
Wow. Well, thank you so much. Well, I'm almost 6 months pregnant. I have 3 dogs over 95 pounds and playing in the background. I'm from Cleveland, Ohio. I work in Atlanta. I work for myself. I kind of threw myself into the front lines being like a private public defender, basically. Like, I didn't work for anybody else. I worked for myself, but I took murder cases for the amounts of money that nobody else probably would, because I wanted the experience and I was ready to go. And I tried a bunch of cases. I've won some. I've lost some. I've been humbled. I felt less powerful now than I probably felt at the beginning, when I was just winning and didn't realize everything else that goes into it. I'm not like a true believer in the sense that I think that some people are guilty, and I do believe in consequences. However, I also believe in restorative justice. I'm disgusted at what happens in jails and prisons. So Shane Kendall was my client. He ended up dying in custody after 2 competency trials with Adrian Love. So I feel traumatized by the system that doesn't work, witnessing it happen in front of me, caring about my clients, and then having really bad things happen to them. So yeah.
Well, and like you're saying, as a public defender or your defense attorney, you start to recognize that not every case is a death penalty case, right? That humans have frailties, and sometimes things are misdemeanors, or some things are civil infractions. Some things, like in a domestic violence situation, you've dealt with those. I've dealt with those a lot. Sometimes people just need help, and the police come and separate the parties, calm everybody down, get it. The person goes to jail, and then the wives, they're like, oh no, he didn't do it, because they want their husband back, they want their loved one back.
I want them both in counseling. Take them
but
to
then you get these
together.
prosecutors, they want to grind that person up, destroy their income, destroy their future, incarcerate them, to punish them. And it's like, and all you're doing is destroying people. Same thing with
And
like
their children.
their children, like my client who works late for 30 minutes and gets 22 years in prison. It's like, what kind of system is this, that we're destroying people? I got a case I just talked to somebody about that I can't talk too much about to identify it. But it was basically an 18-year-old getting in a fight in a school with a 17-year-old. And the 18-year-old beat the 17-year-old up. Okay, well, that's a battery. Okay, battery. They charge it with felony child abuse. So now they want to hang a felony on a first-time offender who's basically getting a school fight. It's like, really? You wanted to put a felony on somebody at 18 years old to have that anchor around their neck the rest of their life? That's you, Mr. Prosecutor. That's justice. That's good. You're making the society much better by your being in there. No, you're basically hurting people. You are hurting the people that we're here to protect.
And not being real about who you are. I mean, I tell everybody, I say it here, I don't really care. I'm pregnant, so I'm not doing it right now, but I mean, I enjoy cannabis. I love cannabis, and I can't stand, I need it when I do. My dogs, they're just, I'm gonna send them outside in a second. But anyways, I'm like, my client got caught selling weed. Well, like, I have to buy it from somewhere. Like, what are you so mad at them about?
It's a lever for the cops to get in your car.
No,
I smell weed, and everybody smells weed. And it's funny, they always smell weed and then they find pills.
I'm like, anyways, to think that like you were 18 once and never got in a fight, or that you weren't at a party where people were doing coke, or you weren't, just shut up already. Like, we're all, I mean, unless you're like that big of a loser, like you've done something that you shouldn't have done and either didn't get caught or were able to have pay an attorney to get rid of it. Have some sympathy, especially for the ones who really have horrible parents, which I have a lot of love for people who I feel like if I were raised by their parents, I would also be in very big trouble. And again, we don't help them. We just say, like, we'll take away your father and hope that your mom can support you. Good luck. And then we just take an entire generation of people and screw them.
Yeah. No, it's, the system, you need mature human beings with an understanding of humanity in the prosecutor's office. And because without that, you get human destruction, because it's a weapon. It's a weapon against the people, and it can destroy people. It grinds people up. And, and this is very important to have that understanding. But instead, when you have prosecutors who are making stupid decisions like charging an 18-year-old with a felony for getting in a school fight, that is harmful to your community that you're supposed to be protecting. You are becoming part of the problem, not part of the solution. And sadly, it's funny because when I dealt with, I didn't do this internet thing until, I don't know, a couple of years ago, 2 or 3 years ago. And I didn't realize how widespread the problem was. And now it's like, when I watch trials, I think I calculated it, half the trials that I've seen had prosecutors that were outrageously out of line. Half. And that's really bad. That means there's really needs to be check on prosecutorial power. And I don't quite know what the great reform is, but it sure isn't happening now. I do have one reform. One reform, I have some solutions in my book, Ideas and Answers in Law, on the prosecutorial misconduct issue. And that was that there should be, like, when they have child abuse in school, there's mandatory reporters. Okay. Same thing when there's an appellate issue and an appellate lawyer files a prosecutorial misconduct appellate argument, it's a mandatory referral to the bar, and it's a mandatory complaint. And that goes from the AG's office, the prosecutor's office, and the appellate judges. They must report it to the bar. because whenever there's prosecutorial response, so that the bar can look at it and actually look at these things, because there's so much disincentive to actually file a complaint against the prosecutor, because you work with them every day. If you file, that you're the defense attorney that filed the bar complaint on me or my colleague, right? I'm going to give you a bad deal. So if there was mandatory reporting at the appellate level, that would provide some incentive for them to at least be better behaved.
I love it. On that point, my father always, warns me, because I say a lot about Adrienne Love, and I'm pretty open about just how much I despise her. And what I explained to him is like, yeah, I guess there could be consequences for that, except there are good prosecutors out there. There are decent people out there. And there are ones that work in the Fulton DA's office. And when I say what I say about Adrienne, I promise you, quietly they're applauding me and I call it silent likes. They silently like what I'm saying and they agree with me. I know people on her prosecution team that are probably horrified, that are basically horrified to be working for her, but
yeah,
they still do.
Well, and those are workmen, and those people need to be supported. And one of the ways to support them is by getting rid of the corrupt ones, the ones that are doing these bad things. But the thing is so many state attorneys' offices are so hungry for prosecutors that they don't want to get rid of anybody unless they speak up or write a nasty book. Right. That it's like, oh, you're bad. We don't want somebody saying, rocking the boat. If you actually try to take a stand on something, then you stick your neck up, then you're going to get chopped off. But if you're just a bureaucrat, power goes right to the head.
Well,
I don't know.
So I was thinking back, trying to finish my RICO thought. So the reason that they also are able to take these cases, they are expanding their power. So when you've got 6 attorneys working on one RICO case, that takes attorneys out of other courtrooms when there's a backlog. Right. So then they apply for federal grants and get lots of money. And then they're accused of misusing the money for their boyfriend that they hire as a special prosecutor. That's what happened.
Come on, Rachel. That doesn't happen.
Where's that happening? I actually was talking about forfeiture. I was talking about forfeiture today because they take people's drug money and they won't give it back. And I'm like, there's no receipts for them making it some legal way. And then respectfully, they have, Fani Willis talking about no receipts and cash in a shoebox in her house. So how is it fair to take money from drug dealers? Just personally, that just drives me crazy. And also I want to say that what's very disappointing about all this. And I knew Fani before she became the DA. I actually campaigned for her because I hated her. The predecessor was really bad, but he's also the one that I guess trained her and trained Adrienne. I had lunch with Fani Willis. I remember where we were. And I told her about Adrienne and what had happened during Shane Kendall's trials. This is before Shane Kendall died. It was pre-November 2020. I explained to her how dangerous she was. She still hired her and she put her on this case. And then even all these months later, when it's clear that the world is seeing Adrienne for who she is and just how unethical, and calling her unprepared is like really minimizing just how far she'll go to win. I think she's more prepared than you think. I think it's not disorganized that she just found that file. I think it's purposeful. Having known her for all this time. Anyways, Adrienne she still ended up on a huge case. Fani still kept her on the staff. And for that, you have to weed out the bad ones. And Fani chose to hear what I said, how bad she was, and put her at the center of a huge case. And what does that say about her? I used to love her. She knows
now, luckily, in all of this absolute fuster clock it's open. People are actually watching this, and nothing against your articles and books, Steve, but the public perception of this trial through new medium like YouTube, Rumble, Twitter, X, when people actually, what's going on here? How is this allowed? And I think the wake-up call came when Judge Glanville was recused, forced to leave. And all of a sudden, because this has been just a long, boring trial in the background for many people. I mean, I started covering this in May of last year, but all of a sudden it rose up to even people who normally don't watch these things are suddenly in my chat. asking questions. What's going on? And now, this next guest I have to bring on immediately because they said they only had a few minutes.
Let's go.
First time on this channel. Blvck Law Student.
We've been wondering, man, the legend. Okay.
How are you guys?
I am very good. I am very good. I'm very happy to have you here.
Yes, I was going to be a man of my word. I just got done doing a spaces, so sorry, I was consumed with
No
people.
worries whatsoever. Blvck Law Student. Introduce yourself for the people who might not know who you are.
I am the Blvck Law Student. There's multiple of us, believe it or not. It's a group of 5 Blvck Law students. We created a brand called the Blvck Law Student. We're all Ivy League third year law students. And we want to develop a brand to highlight Blvck Law students. So
That's funny. What can I ask? What jurisdiction you plan on practicing?
I'm going into corporate. Majority of my internships was in the Southern District of New York's office under Damon Williams, my good friend. So I kind of want to stay close to Damon. Actually, your name looks so familiar to me. I feel like I read a book.
Yeah. Well,
Is it net
one?
positive, net negative? Is that you?
Yes.
Death
yes.
penalty.
Okay.
Yeah.
Okay.
Yeah, death penalty debates. Net negative.
Yep,
Yeah,
there it is.
I've written 3 books on the death penalty. One is called Death Penalty Desires, which I got fired from the state attorney's office for writing. And so I've been fired by 2 states attorney's offices, I can proudly say. The second one is Death Penalty Debates, which is the public policy debate. And the third is called Death Penalty Designs, which is basically all the constitutional and statutory problems with Florida's death penalty. The first book is actually a book about, it's a designed as a factual walkthrough about from crime to investigation to trial to death row, to understand how somebody can get wrongly convicted through and sent to death row based on prosecutorial misconduct. So it's actually a fact book, so that you can understand what the death penalty. So it uses the real law, real life situations that I've dealt with, true situations, and I kind of crammed together a few cases to make one good death penalty case, and put a little murder mystery in there, a little love story, and it got I got libeled by the Miami Herald, and they took it out of context. But that book was the first book of the series. The second book is the public policy debate. The third is the statutory problems, which is it was really designed as an appellate handbook, so that attorneys who are capital appellate lawyers can plug in arguments that apply to all death penalty cases in Florida. It was a work in progress. It's probably about an 85% finished book, but since I'm not doing criminal law anymore, it's going to remain unfinished. But a lot of the ideas in there are gelled. It's just there's a little bit. It needs a little more work, but I had to put it out because I was out, so I needed to finish that stuff.
I think I'm looking for it in my library. I think it's called Death Penalty Debates. I think
that's the second book, which is on the debate. And what I tried to do there was present both sides of the argument as strongly as I can. So many people, I'm 100% against the death penalty. Okay, so given that, I understand the other sides, and I listened to the other sides, and I tried to put them as strongly and as fairly as I could, so that you can make up your own mind. I'm not going to yell at you and tell you. I'm going to give you all my arguments on both sides as strongly as I can make them, and then you make up your own mind based on somebody who's been on the inside and seen it.
Oh, wow. Now, I'm going to ask you a question. Don't be offended by this statement, okay?
No, please.
The friend who gave me this book is Catholic. Are you Catholic?
Yes.
Okay, that makes sense. Okay. My friend who gave it to me is Catholic.
Okay. Yeah,
and
well.
he's always giving me books, but that are written by people who are Catholic. That's why I was like, I wonder, are you Catholic?
I'm a Catholic convert. And actually, one of the big things, I have a religious objection to it. But taking out the religious objection, look like what we're dealing with here with this prosecutor's office. Take, for example, if prosecutors have no check on their power, as exemplified here, do you want to empower that person with the power of life and death over a citizen in this republic?
No.
I hope
No.
not.
There's people like emotionally, there's people I would like to give the death penalty to in my mind, but there's a reason that I'm forbidden from acting on that. And I think that if people are forbidden, then the state should be forbidden. It's like a teacher that's eating in class and tells the students not to eat, or a parent that hits a child and tells them not to hit other kids. It's just unproductive in a civil society.
Well, and I really think, and I've been thinking about it. I think that it is that the idea of the death penalty, which is ancient, and I actually made this point in my third book, which is the hard law book called Death Penalty Designs, which is more of a textbook type thing. But in that book, I did some thinking about it, and I think that the death penalty is an ancient punishment. It goes back to human history, as far back as we know in human history. But what is new is the innovation of free people and we the people and a constitutional republic. That is a modern innovation. Well, to me, the death penalty is incongruent with the idea of a rule by the citizenry. When you have a king who rules over citizens and people, then the death penalty may be appropriate because the ruler is over the citizens. But when the citizens are sovereign, in what way can the sovereign, which is the citizenry, kill its own people? It's almost self-mutilation. So I think it's contradictory to the idea of a constitutional republic.
Well, from this side of the pond, we haven't had the death penalty for over 100 years. With yeah, and then it was only in wartime. Last time that happened.
Well, the point that I tried to make in death penalty debates too is that most people have their arguments, and I have my arguments against, and people have them for, but they don't understand that when they're dealing with a death penalty, they're dealing with a system, and it's a system populated by people. And just as you're seeing this system completely failing in front of you in this case that we're covering right now, that is the same system that will administer this punishment. So you may say, well, I want this person to die because he did a cruel thing. But with that, you're also empowering that same system to execute people who are actually innocent or people who are not guilty of the highest crime. So it's a very dangerous thing to empower your government with the power of life and death over a citizenry.
Yeah, I just covered a case, Marcellus in Missouri, the same situation with him, was sentenced to death, even though the prosecutor said, we don't want him. We'll dismiss the charges. The governor still upheld that decision.
Hey, Blvck Law Student, did you read the book by any chance?
Yes, I have started it. So people just give me books, and it's crazy because I don't know where it is right this second, but I know that name, your name, and I know I had that book, and I know it was net positive, net negative. I just cannot find the book because I write notes when I read books. It's crazy. I'm looking at my library, insane right now, trying to find this book.
Okay, well, thank you. Thank you very much.
Really quick, I just wanted, on that note, it's just really hard for people in positions of power with the Marcellus case, Marcellus Williams. This is just watching the higher and more power that you have, the less likely that you are to apologize for what you do, and the less likely you are to admit that you are wrong. I don't know what they're so scared of. There's like humility and reality and truth in just being like, it's possible we got it wrong, instead of quadrupling down on what you think, what you think you previously decided. It's just sick.
Yeah, and when people are talking about a certain term, which I absolutely hate, they often talk about it, the defense got this guy off on a technicality. Now, Marcellus Williams was killed by a technicality.
Yeah.
Procedurally, they could do it because he exhausted all the things.
I think I did, I don't know what, 20 years in criminal law. And I've seen the number of people, you never hear this term, but the number of people that get convicted on a technicality is way greater. I mean, orders of magnitude greater. Like, for example, the person that's being charged that I talked about earlier in a school fight for child abuse. To me, that's a technicality. Technically, it's correct. You could apply that law. But so to me, if that person gets convicted of that felony, that's convicted on a technicality, right? Yeah. But you never hear that term. Never hear that term.
That's what they can't do.
Right. Technicality is like the Constitution.
Yeah, which should, but then they teach you in every other area of law about the idea of reasonableness. Everything else is about reasonableness, and then I feel like in criminal law, it like isn't. Like speeding. Yeah, I might be going 75 and a 60, but like if everyone else is going 75 and we're driving safely, what's unreasonable about that?
Now,
I don't know why it's strict liability.
Yeah. Now, Black Law Student, I wanted to ask you about the letter, the most recent one, because Detective Sergeant whatever. Now, for Gosney's sake, Detective Sergeant whatever it is or was, left after 19 years, not 20 for full pension. Took a job at the neighboring county's district attorney's office as an investigator, left after 3 months. Now, I do labor law. I've been doing that for all my career. And that tells me that twice she has been given the option of either you quit voluntarily and you can move on, or we will fire you. Now she is, thanks to Black Law Student, because she's currently the
Director of Security.
Let's have Black Law Student talk about this for a few minutes.
No, she's the Director of Security at the Atlanta Hawks.
Atlanta Hawks. And please tell us about this recent letter you and your team wrote.
So we wrote a letter asking the CEO of the Atlanta Hawks to reconsider the hiring of this woman based on her actions, based on her performance, her candor. You know, like, this woman should not deserve to have a job. I think it's inappropriate to the brand to hire such a woman like this. The way she conducted herself was inappropriate. And I think it's very, very telling about the ethics and the hiring practices of the Atlanta Hawks. So we wrote that letter. It got retweeted by tons of people, a lot of folks, Ashley Merchant, a lot of high-profile lawyers in the area retweeted it. It got about 100,000 mentions with the CEO's name on it. Yes, that was done yesterday morning. And then yesterday afternoon, late yesterday afternoon, I received a letter back from the CEO's office asking me, they got the message, forwarded HR, Human Public Relations, and they want to sit down and meet with me next week.
It's amazing.
Yeah.
Congratulations.
Yeah,
That's change. That's
congratulations.
making change.
And you know, and this letter is not about me, it's about us. A lot of people are frustrated, and I want to be an advocate for people who can't get that type of attention, who don't have that network. So I'm glad that he agreed to sit down with me and talk about the issue. He finds it of concern, and you know, and I don't take it lightly that thousands of people have retweeted his name. So it got the attention of the social media department. So there's a hashtag going around Twitter right now called Not Gaither. So you can have security, but not Gaither.
Yeah, and when it comes to Gaither, I mean, as a general principle, I'm how do you explain this? A normal person using their First Amendment rights or the freedom of speech, like most countries in the Western world has, that should not affect their position of employment. But Detective Gaither uses her former position in order to ruin lives now. And we've seen some testimony on Twitter and elsewhere about people who have encountered her in her position as a security officer for the Atlanta Hawks, doing an absolutely piss poor job at it. Being rude, being, everything in between. So, when you do that,
people are tired.
And me, as doing labor law, I can only defend a person like this to a certain degree. If I handle this case, for example, I've handled cases with really, really obnoxious people who has employment. And sometimes it is just, okay, please buy them out. That's all you have to come with to an employer. Yeah, we know, but give them a few months of salary and let's move on. And that would be my suggestion if this goes forward. Now, I'm biased because I think Miss Gaither is an absolute moron who probably butchered more cases than most cops I've ever seen taking the stand in a case.
For sure.
And she became cop of the year in 2016 in Atlanta, which is quite funny because they are starting to have quite a series of awarding people who are absolute bad. For instance, I saw today the most recent cop of the year was shot and
Oh yeah.
killed. Yeah,
That was
shot
in
and
Douglas.
killed.
Yeah, I think he was from Douglas County, but yeah, like some lead detective broke into someone's house and got shot and killed.
Yeah.
Yeah, these are the lead detectives. These are the officers of the year. Gaither moved up in the Atlanta Police Department because she wasn't responding to 911 calls when that was her job, and they had already trained her, so they're like, let's just put her somewhere else.
Yeah,
That's
she was
how
department. She was
It's
department jumping until she became an investigator in the gang unit, and
It's
for
almost like
me,
she hates herself. I feel like she really hates herself. Is that a weird thought? I just, she's on the stand. There's got to be guys on the Hawks team, on the Atlanta Hawks team, that love Young Thug, that have been friends with Young Thug, and she's like just socially. I mean, I feel like she must be hating herself right now. She's almost throwing the case by being so horrible. I think because she's so embarrassed of what she did all those years ago with his case, and she probably feels the social pressure of being considered a loser for not only just doing a really crappy job, but also like going after Young Thug with like no evidence.
Yeah, but remember, when she was specifically asked by Prosecutor Love, is this your file? She said yes. Positively, affirmatively, yes, that's her file. And then they found out it's not her file. It's a copy of her file sent to the DA's office that somebody at the DA's office has used as a work product. So she couldn't have testified yes to it because, first of all, it said copy on it. And it contained material that she didn't write. And yet she was on the stand prepared to lie.
Yeah, no problem.
To the jury.
Confidently lie like it's nothing. It's scary.
Yeah.
And what's so interesting, the response that we have gotten is very good. Before I got on here, I was looking with the team. We have about 36 people who are season ticket holders who have sent me messages saying they're not renewing their tickets until this conversation happens. So that's how you stop corporate America. You hit them where it hurts.
Yeah.
And to let them know that she's not going to come. She's not going to save them in the event of an actual emergency or issue. She's not helping anybody. She's not moving quickly to help anybody. I promise you.
Now we are an hour and 20 minutes in. I have to address the extremely generous people that has been watching so far. Stephen gifted a membership. Kat gifted 5 membership. Thank you so much. Elizabeth Wright gifted 5 memberships.
And I think Stephen's gift. Can I point out Stephen's gift went to Fiery Red Podcast?
Yes, I saw that.
Who is somebody that is, Thank you, Stephen.
Yeah, thank you. And then Steph JK gifted 1. Steven Satchel again gifted 1. Steph gifted 1 again. Elizabeth Wright gifted 1. And then Dolly Talk. Hey, Dolly gifted 1. And another 1. And Steven gifted 1. And then Kat gifted 1. And now Elizabeth gifted 1. And okay,
look, Elizabeth. Elizabeth looks like she's the prom queen. You see the look. Go back to the Elizabeth there. That was look at that. Look, it looks like she's got a crown on. She looks like a prom queen.
Yeah.
I love it.
Now, Sandy for $10. Can somebody explain Love stating, quote, "What I say is not evidence"? or this does not go to the truth of the matter. As a juror, I would be so confused.
Okay. Fine. So what she's saying is that the court is going to instruct the jury that the questions asked by counsel on both sides, the things said by counsel, are not evidence. She's basically trying to suggest that the crazy things that come out of her mouth are somehow not error and not a problem, because eventually a judge is going to instruct the jury that what she says if it isn't evidence. So she's going to the bounds of like what you can say that isn't evidence while still being trying to be as unethical and persuasive as possible. So when she's asking questions, I think I don't know if it was her or Hilton asked a question about like, well, isn't everything that you said in your testimony verified by other evidence? Which I understand that question is not evidence. However, as the person wearing the pin that works for the state and appears to be the epitome of authority, when you ask questions like that don't actually give you the facts, but suggest that there is verification, you're misusing the fact that you can ask questions and that they're not evidence to try and persuade the jury. She's playing with that. I don't know if that answers your question. It doesn't go to the truth, but you're trying to go to the truth, and that's what's wrong, Adrian.
And Steph can't hang, so you're showing some panel show love. Okay, thank you, Steph. Amber, we love you, Nick. 4M YSL cat chat slat conspiratorial gang as we wipe our noses with our index finger. Yeah, this is slime. When I was a teenager a very, very long time ago, that was what we jokingly said, missing our wives. And it's gross. Yeah, my apologies. And potentially criminal. The sad thing is that Love has been doing all these dirty tricks her entire career. It's not just because this case is so important. Yeah, she has this track record. She really has. Harp City,
Yeah, it's
Rachel.
so sad.
Yeah.
Well, I'll go to finish your thing because I have a thought.
Harp City, Rachel, have you ever seen a RICO case in Fulton County where no one follows the money? YSL seems like 2 murder cases plus people in pigs that grew up in the same sector.
Harp City, you're onto something.
And I don't really even know if this guy did it or not. I mean, that's beside the point. The problem is the system is so broken here. What they're doing is so unfair and improper that it can't be a just outcome. An unjust system, an unjust process cannot produce a just outcome. So they need to declare a mistrial and start again, because whatever comes out of this is irrelevant because it's improper. It's not due process. This end justifies the means mentality that is infected our culture and prosecutor's office is something that needs to be done away with, because process is what determines justice. Only a just process can determine a just outcome. And that's what people forget. It's like, well, he's guilty, so whatever it takes to get the guilty verdict is fair. No, that is not what it's about. That is not the system. A prosecutor upholds the law by following the law every step of the way along the process.
Yeah, I mean, it's like a surgeon that is skipping steps in your surgery. I don't think people understand. There are things that they should. Yeah, I don't need them only stitching half of me back up. That just can't. You can't expect the surgery to have gone right if that's what you're doing. As it relates to RICO, again, they misuse it in Fulton County. So I've seen it with the teaching scandal. Didn't really involve money. I don't really think that they're alleging that the Trump situation really involves money. So they're just.
No. Well, there's a number of things that are problematic in the prosecutorial toolbox that tends to, and one of them is conspiracy. Another one is obstruction, because they're basically so elastic that you can kind of shove any action into the pot.
Party to a crime. Party to a crime is my favorite that's misused in Georgia. I mean, the concept that you would somehow encourage somebody by being their friend. I rent somebody a car and somehow I'm responsible for what they do in the car, whether that's hook up with a girl or go and shoot somebody. I don't know what they're doing in the car.
That's charging the postal office because somebody sends letter with drugs in them. No,
Well,
you
I
don't
had
do
a,
that. I mean,
Yeah, you know,
one of
and,
my,
and
go ahead, I'm sorry.
no, sorry. Yeah, you know, I always my fight has always been that I don't really care if they've done it or not. It's the fact that they're not getting a fair trial right now.
Right,
Yeah.
And
Yeah.
exactly.
how
How can we
and
determine?
how can this be a cure for a biased judge? This
Yeah.
Right.
cannot be the cure for a biased judge
That's right. And
at
we
all.
need to pay attention to every action that we do because this goes to justice, especially the prosecutors. They're supposed to uphold the law. You uphold the law by following the law, not cheating. I mean, what the hell is that?
You know, and I just
Yeah.
hate when like prosecutors and even lawyers, judges. I really don't like when judges get behind this limiting instruction thing. Limiting instructions are jokes. They're just not. They're not.
What do you mean
they
by that?
really.
Explain that. I mean, what do you mean?
Curative. I think he was
Yeah,
saying what I was saying
curative
earlier.
yeah.
Yeah, curative limiting instructions like that does not work with juries. That's my understanding of it.
Mm.
You can
Yeah.
tell them, oh, disregard this, disregard that. Like that really doesn't fly.
Yeah.
There's
For
no
instance,
evidence they can. There's no
Yeah, no.
evidence that they can.
For instance, Woody, Mr. Copeland was on the stand when the judge was recused. And the curative instruction was you have to forget 3 out of the 5 days of testimony.
Yeah, but the problem was not that. The problem was that the judge and the prosecutor met with a testifying witness without the defense counsel present, without any that is a mistrial every day of the week. I can't believe this trial continued after that.
You know,
Yeah.
and that was my fight. Listen, ex parte, it happens, right? That's not like a nuanced thing, right? There's ex partes that happen. The problem is if no one said anything, the judge was going to sit there and just allow it to happen. Nobody was going to tell anybody.
He was
When you
he was
think about,
he's going to put Brian Steele in jail for not telling him who told him about it.
yes, that was his worry.
Oh, I
Listen.
remember now. Now it's going back. Boy, this is going back a ways. But yeah, see, this is just the fact that this prosecution is going on 150 days or whatever it is. That should be a mistrial right there. I can't understand in any world how you could ever do a trial that would be that long that could result. It's so random now. What's the jury thinking? Are they like, I mean, they are completely tuned out. You've abused them to the point that either it's just going to be a quick knock, like get the hell out of here, or they're like, we're committed to convicting. It's going to be completely divorced from any evidence that's been presented because it's so long. Nobody can make a decision based on this kind of length of trial. It's an abuse.
Back to
then,
Blvck Law Student, because I cut him off when he was talking about the ex parte thing. I just had to get that in. But the ex parte thing, they didn't tell anybody. And then they
and that was Glanville's. He was mad about who told you. He wasn't mad about anything else, but who told you.
Yeah, that was a cover. That was a cover move.
That's when you get cheated on. That's what happens. I joke. That's like what happens when like you look at like your partner's phone and they're cheating on you and they're so angry that why are you looking at my phone? It's like, why are you cheating on me?
Well,
like,
who is the there's one of the big law commentators, I forget what, but he's in the Atlanta area and he was doing some really good commentary on the trial at that time. And he said that judge that was on there that got disqualified was generally a good judge, but he didn't recognize him in this trial. So I don't know.
I loved him. Our dogs went to dog parties together. I mean, I'm friends. We're friends. I've tried cases in front of him. He's a tough judge. I've never seen him.
Something got a hold of him.
What's going? To me, what's going on? And I don't know. It's bizarro world. And to me, the appellate court should step in at this point. And I know that they did it, but they should shut this trial down. It's absurd because it's wasting everybody's time. And what are these defense attorneys? How are they making a living? How are they getting paid? I mean, you could destroy these people's careers just for being on this dumb case. No lawyer should have to put up with what's being done here.
I will say this too, and then I'm sorry, Nick, I do have to run, but I would say that this whole case started with the ex parte, right? The grand jury. To me, that's an ex parte. It's one-sided. The whole charges were brought against. It's one-sided. The prosecutor brings up all their evidence.
But that's
with them.
That's part of the system. I'm not objecting.
Welcome to the horrors of the criminal justice
yeah.
system, law student. It will make you sick the whole way through. Wow.
One of the
Yeah,
famous judges here in New York, his favorite line was, a good prosecutor can indict a ham sandwich. And it's so true.
Well, the two that goes back to unchecked prosecutor power, but the key element that is missing from these prosecutors is something called humility. Humility. And a little bit of questioning, a little bit of less ego, draw the ego back. And I remember I've talked to Clarence Thomas a couple times, and one of the things he said to me that always inspired me and always resonated with me, is a very impactful thing, is that in all things you should be humble. And like when he walks into those huge courtroom, this huge, temple of law, it's like we are not worthy of answering the questions that we're being asked to answer. And you recognize that as you walk in, and it's like, but that's my job. I've got to do the best I can. So I'm going to work the hardest I can, and I'm going to do the best I can. But always remember at the end of the day that these are greater questions than we are, and come at it with humility. And that is something you don't see any humility on display here in front of this judge or this prosecutor. They're coming in with arrogance, confidence. They're just going to win and destroy. And there's no humility on display at all. And we need a lot more humility.
But this is not about justice. This is about winning to them.
That's
If this was about justice, Diamond Thomas family should be angry. It's been 10 years, no justice. This has nothing to do with justice. This is all about winning. They want to win.
Absolutely. Again, and against people that we don't even know that there's evidence against. I think to myself, again, as somebody who actually likes a lot of criminal defendants and believes in their ability to be restored, I'm not suggesting that I want Kenneth Copeland in prison or anything like that. But how is he any different from any of the guys whose lives they're trying to take away? I mean, how are we safe with some of these guys out on the street and some of them not? What's the difference? And you're treating some of them like victims when they admitted to you that they did bad things, and you're just ignoring what they're saying to you because you want to win.
And there are bad people out there that do need to be locked up. I'm not against that. I'm a law and order guy, but they need to be done it following the law, doing through justice, because otherwise we just might as well just have a tyranny, which we are close to with this kind of unchecked prosecutorial power.
Yikes.
And I'll say this, a couple weeks ago, I sat down with Paul Howard. I'm releasing the episode on my podcast coming up in a couple weeks, the ex-district attorney for this case. And one of the profound things he said to me was, when you indict cases, make sure that your witnesses are credible before you indict a case. So that says a lot about this case.
Coming from him, my eyes
and
roll.
for Steve, Paul Howard was the former DA of Fulton County who did not bring this case.
But Paul Howard, you know what? It's really easy for politicians, and even fine, they can say a lot of things. I've tried cases against his office, so he was there from when I became a lawyer until 2020, and that's some bullshit. Sorry.
Yeah.
Sorry, Paul. Sounds nice.
You hear, if you want the truth from a politician, you have to talk with them after their career is done.
He's a defense attorney now. Paul Howard's doing defense work.
Oh, yeah. Okay.
But listen, Nick, I gotta go.
Yeah.
I thank you for just giving me an opportunity to step up here.
You're a hero.
Hey, great meeting you.
Thank you,
Blvck Law Student, and I appreciate it. Anytime you need anything, just drop me a line.
For sure. And when I find that book, I need you to sign it because I met an author.
Yeah, here's the let me see. Here we go. There it is right there.
Yep, that's the book. Oh my God, I'm going to go crazy until I can find that book. Rachel, thank you.
You can always buy another one.
Lovely to meet you.
I go on Amazon if I can't find it.
I might buy one now. I don't know. In the presence of really amazing people.
Nick and Rachel, thank you guys. I do see your reposts and your likes. So, thank you for just supporting our movement here.
You're a hero again.
Thank you for finally showing up.
Let's not make it a long time. I will be back.
I would. I resend invites to regulars, and I hope you can be a regular or semi-regular person on this Friday panel show going forward.
I'm getting ready to study for the bar, so it's going to get a little hard, but we will try.
Can I make a quick recommendation? Is do more than one bar, because if you ever want to escape the state you're from, it'd be good to have that second bar license hanging in a very easy and a state that has a lot of cross-state jurisdictional sharing. Like Florida, we only have one state. We don't share with anybody. So get like go to a state that shares with a lot of people so that you can spread your bar, so you've got a whole country you can practice in rather than just.
I did not
one
take my
jurisdiction.
father's advice when he gave me that same advice, and now I'm stuck in
Yeah.
Georgia.
Yeah, so that's actually what I'm trying to prepare for. You know,
Yeah,
I kind of
shit.
want to stretch it out as far as I can stretch it out.
Coast to
All right,
coast.
God bless you. Good luck on that.
Well, thank you so much, Nick. I'm going to
Thank you
drop
for
down
being
and
here.
listen, but thank you so much.
Catch up.
Thank you for being here. Thank you.
Thanks.
Okay, let's try to finish off these great sponsors of this show. Elizabeth Wright, let's get this like up, chat. Yes. For you who noticed, I don't have midstream ads. I understand those who do. I don't. And that's my gift to you. Your gift back could be the thumbs up and subscribe if you haven't yet. Then Amber Dawn said, can we read BLS letter to Whitaker or to Thug? We can do that. I can do that later. But now we heard it from Blvck Law Student himself. So, yeah. Blue Skies, bring this panel back. We're still here. But yeah. Yeah, definitely. I will be sending them invites as I always do. Amber Dawn here again. It should be statute. Career prosecutor shall not take the bench.
Well, actually, you know what? I think a better solution than that. I don't agree with that. I think that instead what should happen is every 3 years, the defense attorneys and the prosecutors should switch sides.
Yep.
You know?
Yep.
Because then it's like all of a sudden these prosecutors, they come out and they're defense attorneys and they're like, I can't believe all this prosecutorial misconduct. It's like, you know, they should have to serve on, or, you know, I know in England they do that. In England, the barrister is assigned and they just show up and it's like, okay, you're on the defense side this time. And so that to me, there's an arrogance about prosecutors. It's like, I am going to solve the world's problems with my sword. And they end up cutting a lot of people that shouldn't be cut. And, you know, and maybe even defense attorneys too, like you can get in defense attorney world. It's like everybody's innocent. Nobody did anything. There's no crime at all, right? So I think switching hats would be helpful to both sides.
Keeping everyone fair. I would love that idea as well. And I think there should be either a panel of judges. I think that jurors should. I think there should be like. They shouldn't be necessarily the foreman, but there should be a panel of attorneys in a jury room guiding deliberations. We could talk about juries another day, but I just have so many opinions about what goes on behind closed doors. What is deliberation? Do jurors actually deliberate? You think to yourself, what happens when you don't have people who appreciate conflict? I mean, whereas we may sit in a room and hold our own because we're the kind of people that like to play devil's advocate or are strong enough to withstand 11 other people telling us that it's time to leave and just to come on board. I mean, most people are not going to sit there and hold out. And just the desire to be agreeable sometimes takes justice and skews it. So I feel like there needs to be some sort of oversight as to what's going on in the jury room. It's very dangerous.
Yeah. And thank you to Elisa Mia Miranda for your super sticker. And I saw that was your first super chat or sticker on a live stream. So thank you so much. I'm very honored that you chose my little channel to do that. Thank you so much. Elizabeth, Fulton County, Kangaroo Court. I think Aussie Overlord would not agree to that, but he's Australian, so
come to the zoo.
Yeah, it's a fake country anyway, and
that's great. There's some big city problems. We have, there's some problems with urban living, and I don't know what it is. I've experienced it in Miami, and it happens all over these countries, in these inner cities, and these big cities. I don't know. It's insanity. I think people get in their little cubicles and they live in their very constrained world, and they forget reality of life. And it's a problem societal wide. Yeah. Cheers to you, by the way. This is the finishing of the drink.
I want a drink. It's so frustrating.
Oh,
yeah.
When do you do, buddy? Can I ask when you're due?
Yeah, beginning of February, but I'm hoping for end of January. I'm 38 and I'm never doing this again, is all. I mentioned in the comments. I mean, I'll be very happy to have my son when he gets here, but
So it's
Not-
definitely
Yeah.
a boy. Is this your
It's a boy.
first?
It's my first and will be my only. Yes. Yes.
And you're only, well, okay, I've got one boy, and he's my only, and he's great, and it's the best thing ever happened.
If I could be a dad, I'd have more than one. I'm a mom. So
I understand. If it was up to me, I would have more too. So, but the wife is the one that has to do all the work.
yeah, it is a lot of work.
Now, this is good. Stephen T. Satchel, thank you so much. I think love is weaponizing plea deals to insert inaccurate information. Can someone post a link to my essay on plea deals?
Oh,
somebody
Stephen
did.
Satchel. Oh, really?
Sounds
Let's see it. I want to read about. Actually, one of the things that I was supposed to write at the Miami-Dade State Attorney's Office, I was developing a written policy manual, but I only got through 2 of the number of projects that I had. And one of them was creating guidelines for the prosecutor's office to do plea deals, and how they use people that they have done plea deals with in other cases, because that's rife for abuse, because those people are very vulnerable to coercion and plea deals. You can get them to say whatever you want. I'll lie. I'll tell you whatever you want. You give me that plea deal, right? And that's a problem. It's a danger. And it's very easy to self-delude, to think, well, I want him to say the truth, and I know the truth, so you're just going to tell me what I want to hear. And it's a self-referential kind of feedback loop that the prosecutors aren't even aware that they're doing. So you need to have very strict guidelines, but I was not able to get that project started.
Yeah, and in this trial, you have had some interesting plea deals with coercive testimony, where love put people on the stand with plea deals and immunity in order to get them to say what she wants them to say. And yeah, let's just the latest one, Quintarius Zachary, was touch and go because he was hospitalized with sickle cell anemia. He had 3 blood transfusions in 1 month. And then they called him to the stand, and the family said, he's sick. Hey. And what does Miss Love do, or Miss Hilton do? She sends him to jail to ensure that he shows up. So he's fresh out of hospital, 3 blood transfusions, sickle cell, and she puts him in Rye Street. And from Rye Street, he had to go back to hospital. But once he got on the stand, and it was a fustercluck of a testimony that really didn't help the prosecution at all. Because again, they put things in there that simply wasn't true, because when they signed that plea deal back in 2017, I want to say, his mother was dying. He has been in 2020. So his mother was dying. He has been in jail since May of 2022? Jesus Christ, everybody's... Well, he was in Rye Street for 6 months and then was handed a plea deal. Of course, he's going to sign it. Because he wants to get out, he wants to get home because his mother is dying. And now all of a sudden he was on the stand and saying, yeah, I know I signed it, but I asked you to change it. Because this simply isn't true. And over and over and over again. And that is the 3rd person the prosecution had to jail to get to testify, or people who actually was going to testify, who they jailed anyway because they told the judge, they said they won't testify. And nobody so far said they wouldn't, except Woody. I have your essay up here. We will go through it. I have to go through these first.
So I'm gonna hop off too, because I think I'm
Oh.
pregnant and tired. It's
I know,
really
me
fun
too,
when your
but,
brain just stops working.
Hey, great to meet you, Rachel. It's been a blessing to have you. And
Great to meet you
finally.
too.
Yeah.
Happy Friday to everybody. I hope we do this again. And yeah, lots more to discuss. And I'm gonna get your books. I'm gonna find a way to get them autographed. Where are you in Florida?
Well,
Where do you
currently
live?
I'm in Miami-Dade. I was in Daytona my entire life, and I moved down to the Miami-Dade area to go to the state attorney's office to do some reforms. But they cancel culture got me. So and they fired me. And so now I'm in civil practice doing trucking litigation, civil defense litigation, and learning a new area of law. It's been
Jokes
very,
on that.
it's sad because I really, everybody I met there was very, I really enjoyed it. And I really thought I know what they need. I know what they need. But because I talked in my fictional novel, the Miami Herald did a hit piece on me. And in my fictional novel, they wrote about, I actually dared to call my main character submissive as a female. And you can't call, and no woman is submissive, right? It's a one character in a fictional novel. And then, of course, I also have, and then they also talked about a trans character that I had. And so there was like, you can't talk about these subjects in society, I guess. So they canceled me and they canceled my book. So a bunch of book banners got me. And it's a shame because I really feel like they need, and I was going to tell Nick here about, there is some product from what I've done there and I'm going to put it out, but there's so many projects that I wanted to do that they need that aren't going to get done. I don't think, maybe they'll have somebody pick it up, but as you said, I came down here to accomplish something, to do something about the prosecutorial misconduct that we're seeing throughout the country. I mean, it's one thing to curse the wind. It's another to actually act on it. So one thing I can look myself in the mirror and say that I did something to try to make a difference, even though I failed in that effort. I did try to do something to make a difference. And, we all need to kind of step up.
If they're failing, and again, the humility, it's like the people that are upset and triggered by you talking about a submissive female probably like being submissive in bed. I don't want to hear about it.
Well, it's actually based on a real case that I had. That the
is what it is.
Yeah, I mean, it's like there's no women, there's men, there's no men that are submissive. I mean, there are people that are submissive, there's people that are not. But and it was actually based on a real case I had. It was fictionalized. It's a fictional novel. Why? That people need a fainting couch when you talk about something that happened. I don't know.
You're a white man. I don't think you're allowed to say it anymore. As a white, sorry. I mean, that's
it's true.
You're being punished for things that men did generations ago that are not your fault. So
it's sad.
It is sad. You cannot take it personally. Screw
it was very. Nick has been on top of it. It's been very hard on me personally because I left.
I can tell because you care about what people think of you and you like to be liked and you deserve to be liked and it's confusing. It's confusing. Anyways, good. On that note, good night and screw.
Yeah.
Don't tell me
Rachel.
Come down to Miami and messing people up. Okay.
You're great. She's great. I love her, man.
Awesome. She is an amazing person. Amazing. Now
that's the first time I've seen her. She's awesome. Does she have a channel or is she?
She does have a YouTube handle and she is on other people's shows. I don't know if she has an actual channel of her own, but she should have one. Now, Stephen, Amber Dawn asks, have you seen Shanna Gardner's evidentiary hearing? And I would assume no, because you've been working.
But here's an explanation. Part of the reason I haven't been on is because I'm just tired. I mean, and I want to give my best. I'm really fighting. I just don't have the energy. I don't have the energy to do anything because I'm working full time, very hard in civil to learn the practice and to be the best. Because when I do something, I want to do it right. And I'm, and actually every day that I work, I'm getting better and better at civil practice, and I'm getting pretty good already. I'm pretty good, and but it's going to take some more time and effort. But when I do have energy, I'll try to come on and do things. I will also say on your channel that one of the problems is that when that article came out, I was being paid by the office, right? And they shut me down. They would not let me comment and not let me talk and defend myself. So I could not defend myself for a couple months. And so that was very hard too. So they basically allowed the slander to unfold. But it is what it is. You got to move forward.
Yeah. And Dali, member for 14 months. Thank you, Dali, for your continuous support. Steve spoke with Clarence Thomas.
Oh yeah, actually, I'm friends with his son. Actually, I went to law school with, well, it's kind of complicated and it's kind of personal, but his son and is very good friends with the guy, my best friend basically, and we got to hang out many times. His son and I, and then I got to meet his father twice, and he's an impressive guy. If you ever want to read a really good book, read My Grandfather's Son, which is the autobiography of Clarence Thomas. And I don't, he's not, I mean, I love the guy as a man, as a thinker, as a jurist, probably one of the most influential jurists I've ever met. I talked to him a couple times personally and has had a huge impact on me. However, I will say I don't agree with, I'm probably about 80% Clarence Thomas. I'm like everything he says I follow. I mean, I disagree with him on a number of things, but he comes at things, his attitude and his perspective and his intelligence, basically hard work and humility are the keystones of what he's about. And if you read his novel or his autobiography, it will give you some insights into who he is. And yes, he's a great man, great sense of humor, great guy, gregarious. So is his son, is a great guy. And I haven't been, I mean, he's still friends marginally, but I don't talk to him. But in law school, we pal around all the time. His son, and I got, like I said, I got to meet. Yeah, so that's my Clarence Thomas story. It's pretty cool, I think, but it's kind of hard because I mean, what do I do with that? I mean, it's like he signed a couple books that he wrote. He signed his autobiography. That's pretty cool. But I mean, but really, it was the words that he spoke to me that really had an impact and gave me some guideposts for how to practice law. Yeah.
Tedsko, can I hire a lawyer to file amicus brief on behalf of jurors for cruel and unusual punishment? Well, you can try, but I'm not sure if you can do it on the behalf of jurors because, yeah.
I get it though. It's a funny joke. Yeah.
It's you can try, but I don't think it will work.
Yeah.
Little Dog, member for 8 months. Thank you so much. Nick and Gosney and Rachel, good to see you all. Good to see you too.
Hey, MLS just hit the chat too.
Hey, MLS. Dave is here. Yeah.
Yeah.
Tedsko, if defense calls back Woody, does he still have immunity? Well, he was given immunity during, I do believe he was permanently excused, but that doesn't mean he can't be called as a defense witness. So I do believe that his immunity deal with the judge and the prosecution, or with the judge more or less, once he got released by the prosecution, I do believe, the immunity might have ended with that. If the defense wants to issue a new subpoena for him as a defense witness, I don't know if that immunity deal still stands. I'm not practicing in Georgia and I don't know the rules, but I do believe that the defense didn't object to him being released. But then again, they can always subpoena the people back. The prosecution can too. Even though they released him, they can subpoena him back as a rebuttal witness, technically. So, but I do think that his immunity ended with his release as a witness. But don't take my word for it. Don't take my word for it. Okay. Ooh, that gets us to the end of. Thank you so much, everybody, for the super chats and gifted memberships and everything. Now, I did. Let's see here. Find Steven Satchel's let's see here. Where is it? Okay. I don't know if you're still here. Okay, wrong link. Yep, not that one. Okay. If you can DM me that link, because I'm really, really interested in seeing what you wrote. His essay on plea deals. My general opinion about plea deals, well, we already discussed that it is not as bad as prison snitches, but it's still bad because it is incentivizes people to lie.
Here's the thing: is that they need to be ideally, prosecutors need to be very careful when dealing with these, because on the one hand, okay, there may be evidence, there may be good evidence there, it may be real evidence, it may be the key to the case. I get all that, right? But you have to be very hyper aware of the fact of the great incentives that are placed on a convict, of somebody who has been convicted, maybe even a reformed convict, right? But a convict nonetheless, to plea and to agree to give you, say whatever you want. I'll tell you whatever you want, give me less time. And so, prosecutors need to protect the system from corruption through this. And that was one of those projects that I was working on that unfortunately got cut short, was how to deal with that situation. And the way to deal with it is by following ethics. I had an interview with a professor from Alabama. I forget his name just now, but it was on my Rumble channel. And it was basically his opinion. He had done a lot of studies on this, on wrongful convictions. And basically he said that the prosecutors should be barred from using jailhouse snitches because so many wrongful convictions have come at it. So, and I don't know if I'm quite there yet, but there does need to be great constraints placed on the use of these things because the danger is so great of wrongful conviction and false testimony.
I've been asked by Nancy, no, please show Steve the judge going at love on Monday. I will try to
see the problem. Okay, let's see the problem with this. And I get you want me to see that and react. Yeah. The problem with this is it's just words. It's meaningless. Oh, so she got a tongue lashing. Yeah, that really showed her. Unless you back it up by a mistrial, it's a bunch of BS. I don't believe anything. That tongue lashing, they don't care. It's like, prosecutor, she's getting away with murder. And it's like, now don't do it again. If you do it again, I'm going to say neat one more time, right? Neat, neat, neat. Okay. Say it again, right? I mean, it's a meaningless act. And then people, it's a political, they're buying you. The judge is selling you a bill of goods when they say, they're giving her a tongue lashing and she won't do it again. That's a self-delusion. That's a political trick to get away from making the hard decision, which is granting the mistrial. So I don't know. I don't want to hear some judge talking about how strong they're going to sanction that prosecutor when they haven't done jack to this date, when that should have been a mistrial back a month ago or 2 months ago or 3 months ago.
No. Now, I agree. Now, the one good thing is that this is a part of the record. So with a possible appeal, that can be brought forward. And this was unusually harsh. So I will actually just play bits of it. Because
those are out unless we find out that they were in fact served. So if you find that out, then you can bring that back up to us. Okay.
Yes.
All right. Okay. So then this Zachary transcription, that would come in through Detective Gaither. Is that right?
Maybe it's that one. Or am I at the wrong one? No, that was...
What was...
Is this one?
Or when the state plans on using this?
Nope, not that one either. Damn it. Find this one. Nope. Darn it. Where is it? Lots of breaks. Lots of breaks. Folks in the chat, can you give me a timestamp of day 138? Because I didn't have that lined up. Or maybe
Can I make a radical self promotion since I'm my first
Yeah.
day back? And
yeah, definitely. Yeah. Oh yeah, new book. Yeah. Go ahead.
Well, I want to say that people are aware I'm coming back. I'm struggling back. I'm so worn out, but I'm trying to get back a little bit on the saddle here. And one of the things is that I do have 2 new chapters for my first book, which is called Ideas and Answers in Law, which is my compendium of law review articles that are basically dealing with criminal law, common problems confronting the criminal lawyer, criminal practitioner. So it's a book written for criminal practitioners, lawyers mostly, and people who are interested in criminal law generally, right? And so this is kind of my book that compiles these essays that deal with common problems, but maybe a little more complex than your everyday quick Westlaw searches, more deep problems. And so it's in the second edition now. Now, first thing I want to say is the second edition is now on sale. So I've dropped the price for the second edition by $5. So it's only $20 at stevegosney.com. You can see it down here. So it's at stevegosney.com. You can get Ideas and Answers in Law, second edition, because I've got a few left that I need to sell. And so I've given a discount to people that want the second edition. But I'm also telling you that the third edition is now available for pre-order. And the third edition of Ideas and Answers in Law will contain 2 new chapters, plus some minor updates on a number of things on the intro and the outro and stuff like that. But the Ideas and Answers in Law third edition will have 2 chapters that are derived from work that I did with the Miami-Dade State Attorney's Office. And those were part of policy manuals for prosecutors. So, and this is, I'm really proud of what I did there. I mean, I did develop some good work, and it's not, it's derived from, I've had to put some extra work into these chapters to make them usable for everyday people. But let me tell you about these 2 chapters. So the third edition of Ideas and Answers Law is now available for pre-order on my website, stevegosney.com. And the 2 extra chapters will be, number 1, a practical policy for Florida prosecutors on inadvertent disclosures of privileged information. So basically what happens when a defense attorney inadvertently discloses privileged information? They send you an email that is supposed to be to their client or contains privileged information. How does a prosecutor deal with that? And it can be a setup by a defense attorney, right? So it's a practical way for a prosecutor to deal with that. The second thing is, and I'm really excited about this chapter, and that's called Ethically Preparing Witnesses for Deposition or Trial. And what this means is, because there was this thing called prepping witnesses for deposition or trial, and this state attorney's office got big problem. What happens is they coach witnesses to say what they want to say. That is not proper. That's not the proper place of a prosecutor. But there is, you do want to prepare witnesses for trial. And so this is a guide for prosecutors to not make themselves witnesses in a trial, but to ethically prepare witnesses for deposition or trial. And it's a whole chapter that goes through all the issues. So both these chapters will be included in the third edition, which is now available for pre-order at stevegosney.com. So I want you all, it's my first book, and it's now in the third edition, or it will be in pre-order. It's probably going to come out in about 2 to 3 weeks. I want you all, if you're interested in that, to order that from stevegosney.com. So anyway, there's my big senseless promo, but thank you for listening.
Thank you so much, Steve. Now, thank you to Mia Miranda for super sticker. Says thank you. And then Sylvia Edwards had an interesting question here. When the previous judge and present judge say take up overruled objections in appeal, is that not saying they already believe the defense are going to be found guilty? it's preparation. If the result is a conviction, they can bring, because if they are acquitted, it doesn't matter.
I remember that. That's garbage, though.
Yeah.
That was the previous judge, and I remember when I was involved in this case, and I was watching it with you before, with the old judge, and he would say, "Well, if you don't like it, appeal me." That's a cop out.
Yeah.
That's a cop out, because it's like, oh, because you're going to put me through days of trial, you're going to send me to prison, in a year or two, I might see relief, and they might find because I screwed up, I didn't preserve it correctly, it's going to come. That's a judge. That's an abdication of responsibility. Make the hard call, judge. That's your job. You're getting paid way too much money to make the hard call, and you aren't doing it. And you're abdicating your responsibility to uphold the law by kicking it off to the appellate court when the appellate courts aren't doing their job either. So that is not a good. That I don't like that when a judge says that. I mean, it's basically a cop out. Sorry.
Yeah. No, I agree. I agree. I mean, it is a cop out, because if it is, now certain decision rulings can be in a gray zone, and then of course that should be in the hands of the appeals court to decide if it is in a gray zone. Do we need to address it or not? But other things like the ex parte and this latest stunt from the prosecution, where they violated a direct court order to produce every evidence they plan to introduce with a witness beforehand so the defense can prepare. That is not even close to a question for an appeals court. That should be ruled on immediately. Ms. Love, you screwed up royally. This cannot be curated by me telling the the jury, hey, ignore that.
Yeah, I have
forget
a
about
pretty
it.
fun. I kind of have a funny story though about that. Can I give you a funny story?
Of course you can.
I got a funny story about that, because there was this old judge. I was buddies when I was prosecuting, and I was buddies with the public defender, and his name was Rich, and he was my good friend, and he and I used to have great time together. It was really fun prosecuting, and he was a defense attorney, and it was when I first was a prosecutor. We were doing juvenile cases, and we actually call him Uncle Rich because he was such a close friend. Anyways, we were trying these cases, and it was in juvie. And there was a visiting judge who was an old retired judge, and his name was Robert E. Lee. That was his name, Robert E. Lee. And he was descended from Robert E. Lee, right? This old Southern judge. And we were in juvie, and like we'd do these cases, and I'd say, okay, Your Honor, we've worked out this case. He pleads guilty, and and we're sentencing him to this and this and this. And he'd look over to the defense attorney and say, so defense, is that what you want to do? And the defense say, yes, sir. And he'd say, okay. And he'd slap the file down to the clerk and say, next case. And he'd do that one after the other, right? And then Rich comes over to me about about a few hours into this. And he comes over and he's like worried. He says, man, I'm concerned because every one of these cases is not done properly. He's not going through a plea colloquy. He's not talking to my client. He's not doing things right at all. And he's like, every one of these is error, all these cases, right? And so I said, okay, well, why don't we approach Judge Lee and find out what he thinks? So we walk up to the bench, and he's like, and we say, my friend Rich here is concerned that you're not doing the plea colloquy correct. And so he said, he looks over and he says, appeal me. And I'll tell you, and here's the old judge perspective, because what he was saying was, these are juvie cases on misdemeanors. Nobody, they're all getting their deal. They're going to do their thing. The efficiency of just doing it quick and not going through politically, if you got a problem with it, you could appeal and you'll redo it. But that's 1 in 500, right? It's like you're going to waste so much time going through all this bureaucracy that he's just going to do it. Everybody agrees. Let's move forward. I mean, and so Robert E. Lee was pretty good old judge, and so anyways, that's my appeal me story.
Yeah. Now, I did. I mean, I covered the Eileen Warner's trial.
Oh, yeah,
Last,
yeah. Well,
last episode was,
about that. I have
yeah,
a lot of insight into that case too,
yeah.
right?
I did the last episode a few weeks ago.
That's fine. That's fine.
Yeah.
That's fine.
And
What do you
I-
think about my buddy John Tanner? John Tanner was the guy that hired me as a prosecutor, and he was one of my mentors.
Mm.
What'd you think
Now-
about John?
excellent. Now, he at 2 points in the trial, he did try to circumvent a ruling, but the judge, back you go. And so it was so refreshing. And I urge you people who are here in the chat, the next trial I'm going to do, it's way in the future. I will try to do it's called Serial Killer Saturday for a reason, and it's serial killer trials. But one thing I noticed, because I have done the Dahmer and the Eileen Warner's one, the trials are so clean. And when hearsay actually was hearsay, this is before the majority of all the hearsay exceptions started showing up.
Yeah, and John Tanner, I'll tell you what, John Tanner was a great man, and he's still around actually. But he hired me, and he was a friend of my family. He was the prosecutor in the Eileen Warner's case. He's a real alpha male. He's a real lead dog, and he was a great prosecutor.
Yeah, he fought a bear and won.
Yeah, he fought a bear. Yeah, you know that. Did you know that? Did I tell you that story?
Yeah, you told me that story.
He legitimately fought a bear. He was bow hunting out in Wyoming or wherever, and he got attacked by a bear and fought the bear off with his bow. Yeah, so that's John Tanner. He's a character. He was a real character in our community, but he was a friend of our family for a long time, and I knew him somewhat. But when he hired me, I respect him, and he always said to me, "Gosney, do the right thing." That was his guidance to me as a prosecutor. Do the right thing. And I'd say and I'd ask him a question about some specific case. He's like, "Well, I hired you for your judgment. I want you to use your judgment and do the right thing by your cases." And he'd sometimes say, "Have you dismissed some more cases? You need to get rid of those cases, because not every case is a good winner, right? Just because the cops have probable cause to arrest doesn't mean you should prosecute it." And so he was very much about doing the right thing. And I really, and my actual boss was a fellow named Steve Nelson, who was even greater. He was a great mentor as a prosecutor, a great prosecutor. And, and I was blessed by that. And I didn't realize how dysfunctional the rest of the world was until I kind of got out of that little bubble, because I was trained by such good people. And, and so I think that I didn't watch the whole Eileen Warner's case. I did see him in action a little bit and was impressed.
Yeah.
But I know that by his reputation, he was quite a great prosecutor. And I'm glad that you reviewed that case for the people to see the way it should be done.
Yeah.
Rather than these crazy people that are doing it now that are like, "What are you doing?
Yeah.
Just do it right."
Yeah. Now, Slidey Pie over at Rumble, thank you for
Slidey
your
Pie.
$2.
Slidey
Says-
Pie, God bless you, Slidey Pie. She read my entire book, Death Penalty Desires, on her channel. She read it every chapter by chapter, and she just finished it. This last chapter was just done.
Slidey Pie on Rumble. But when the judge says the defense can take it up on appeal in front of the jury, that seems prejudicial. Glanville
Yeah.
did that.
Good point.
Definitely. Good point. And yeah, some things should not be in front of the jury. For instance, take it up with the appeals court. That is actually the judge, even unknowingly, giving an opinion of guilt. And I don't know if we talked about this last time, but this Detective Gaither, who just got off the stand, when she testified the first time back in April, the defense didn't get her CV until that very morning of her testimony. So the Judge Glanville decided to have the Daubert hearing in front of the jury.
What?
Yeah. in front of the jury. And that hamstrings the defense so much because they want to ask questions that might implicate their clients not in front of the jury, because they want to know the actual expertise of this person. But now they can't because it's in front of the jury. And I remember back then are you serious? You're going to have, and the defense of course objected. And then later on during the testimony, they did some objections that she cannot hear that. And Glanville said to them something, not verbatim, but you had the chance to ask her during the Daubert hearing. And I said, no, we didn't, because we had it in front of the jury. But apparently, Judge Glanville saw no issues having a Daubert hearing in front of the jury. And if that's not bolstering,
crazy.
If that's not bolstering,
That's crazy.
I'm still.
That's terrible.
I might do.
And so people would know let's just say what a Daubert hearing. A Daubert hearing is determining whether an expert witness can testify or not. And there's no way that should be in front of a jury. That's off. I don't know. What's going on in the law right now? I guess it's just a reflection of our society, being so weak.
Yeah, and they have people on that are both laymen and expert witnesses. And if I remember correctly, Detective Belknap, who was also a gang unit detective, was both a layman witness because he investigated cases and an expert witness because he's an expert in gangs. And first half of his testimony was as a layman witness testifying about the case. And then she tells Judge Glanville, okay, now we are switching over to questions to him as an expert. So mid-direct examination, they switched between layman and expert witness. And then he started to bolstering himself. And it was allowed. And I'm just sitting there dumbfounded. How is this even remotely possible to be allowed? And I've never heard of it before. First of all, having one witness as both layman and expert, for me, that is a huge no-no, because that is bolstering of their own abilities as an investigator if you're also a gang expert. And then during the same direct examination, and I don't know. Now, I did find via X the parts of the lashing out. Let's listen to.
Appropriate. I'm asking.
I can't figure out what it is. If it's disingenuous, if it is that, I don't want to malign the prosecutor standing in front of me right now. So I'm not going to say the possible things that it could be, but it is baffling to me that somebody with the number of years of experience that you have, time after time after time, continues to seemingly purposefully hide the ball to the extent you possibly can for as long as you possibly can. And I really don't want to believe that it is purposeful. But honestly, after a certain number of times, you start to wonder how it could be anything but that, unless it is just that you are so unorganized that you are throwing this case together as you try it. And I am sorry to say that, but this case is being made much more difficult for everybody because of the haphazard way in which it is being presented. I'm going to take a recess for a few minutes. I'll have a ruling when I get back.
Yeah, and this was
that's a pretty. Well, there's two things. I got another story.
Okay. First of all,
I got lots.
this was an answer to a motion for mistrial because she screwed up again, and the mistrial was denied. So, as you said, yeah, that was a
Well, I mean, just
lashing.
grant the mistrial and grant the mistrial and be done. You know, all of this is well. Okay, that is actually a very good judge technique. And I think it was when I applied for a judge once, I talked about this technique, but I'll tell you the story. Judge Kim Hammond was my judge. He was my regular judge that I practiced the most in front of. He didn't do most of my trials because he didn't like the trials as much. He handed off in front of a guy named Richard O. Watson, which is the greatest judge I've ever been in front of, bar none. Great Richard Watson. But Kim Hammond was my regular judge. He was a famous quarterback for Florida State University, and he beat University of Florida. And so he's known for that, as being the quarterback for FSU. Sorry, this is a side tangent, but this is Kim Hammond. This was my judge. And Kim Hammond, I remember one time, my friend Rich was the public defender and I was the prosecutor, right? And we were so friendly and we had such a cordial relationship that we would bicker a little bit, you know, and we'd be in front of Judge Hammond and we'd start arguing back and forth. And so we're like, okay, well, here's the issue. And then Rich would say, oh, this is the issue. And then I'd say, no. And we'd go back and forth and flesh out the issue for the judge, right? Well, Judge Hammond's up there listening, and he's trying to interject, and Rich and I are just going back and forth, right? And of course, we're ignoring the judge, which is not good. And I remember one time we were doing that, and he just got up and walked off the bench. And we looked over at each other, and we're like, and we looked over, and we're like, whoa, what was that? You know, because that was his way of kind of asserting his control over Rich and I, because we had our debates already worked out, but he had his own issues and we're here for him, right? So I thought that was a very good judge technique to kind of rein in his prosecutor and his public defender. So there's my story about walking off the bench. But see, that's great for when you're just trying to make a point. But in this case, this prosecutor is so out of line, she just needs to come back and say mistrial. What's the problem? Why not do that? Is mistrial motion never granted in Atlanta, no matter what? It's there for a reason. It's there for the reason that exists right now.
Yeah, and this was on Monday. And then in the beginning of today's stream, we watched what happened 2 days later. She still hides evidence. So get
rid of this case. Get rid of it. Okay, even if the guy did it, I don't know whether he did or didn't. You got to stand up for justice. You got to stand up for the law. And you know how you do that? You grant the mistrial.
Yeah, and we say this a lot.
The guilty guy gets free. The guilty guy goes free. So, prosecutor, you got your way. You cheated enough that I've had to do this. Yeah, that's the only way to get through them.
Yeah, because here's the thing with due process and everything. If you don't grant the rights to the worst of them, you deny it for the people you actually believe are innocent. Because if you accept this conduct by the prosecutor and the judge not getting into a mistrial because you believe they are guilty, now how can you make the argument, oh, but now they should follow the rules because I believe the defendant is innocent? No, you can't do that. That is why these rules should be on top of our personal feelings. I mean, there are the case I covered last year. It was a murder case, which I believe the prosecution mishandled, and it was so badly presented. And I said, I wouldn't be surprised, and it was a bench trial. I wouldn't be surprised if the judge comes back and says that, yeah, I can't convict this guy. Now, this guy, in my opinion, was guilty. It was really, really guilty. But the prosecution had this theory they went with, which, in my opinion, ruined the case. And I said, I would hate for this guy to go free. But the evidence is there, just poorly presented.
Here's the test, though. Okay, here's the test. Would any outcome of this farcical proceeding, would any outcome have would you have confidence in the process? You know, the answer is no. Whatever the outcome, whether it's guilty or not guilty, I have no confidence that this process will result in any kind of just outcome. That's a mistrial.
Yeah.
Just grant the mistrial. What's the problem up there? I really am baffled why it hasn't been granted. Sorry.
Yeah.
I'm
Yeah, but it
I'm
seems-
fully
yeah.
empty at this point. So
Yeah. Now, I'm convinced that there is some behind closed doors. There is an agreement among the judges. No mistrials, just punt it up.
but it's wasting everybody's. It's so destructive to the rule of law.
Yeah.
It's destructive to justice. It's destructive to these defendants. It's destructive to these defense attorneys, to these jurors, and to the reputation of the rule of law across the country. What they are displaying is an absurdity. It's embarrassing. I'm embarrassed as an American. You're here watching in Sweden, and this is our system, and we're supposed to be the shining global shining beacon of democracy. Give me a break. And this is what we're saying is justice. They laugh at us. You know, I mean, come on. This is not a good. This is really bad. I mean, every time I watch this trial, and Nick, you've been following this trial from day one. You are the guy. You are the go-to guy. Are you impressed with America's justice system here?
No.
Yeah, I mean, it's embarrassing.
Yeah, and I'm. Oh, hello.
I will say that this is not the. When I was prosecuting in my jurisdiction, I mean, I never. This is so far from anything. The longest jury, I mean, I've never had a jury trial over a week. So, you know, and I mean, of course, I believe, and this is what I would train if I ever had the opportunity to train prosecutors again, which ain't going to happen. But I mean, I would train them to be efficient, respectful of the judge's time, the court's time, the juror's time, the defense time. You know, you get to the point, you present your evidence, and you get out, you sit down and shut up. This prosecutor is all about her ego and all about showing off and being in front of the camera. And I don't know what's going on here, but it's not justice and it's not law.
Now, for the past almost 2 years, I've been covering just about maybe 20 trials, and I've been watching and double that amount. And it's now that is still a bit limiting. But it seems like the longer the case, the worse the evidence. Because all of a sudden, the prosecution needs to tell a story. When it is the evidence that should tell the story, not the prosecutor.
Why? Yes, exactly. I mean, exactly. I don't know. I mean, I guess we're just spitting in the wind, but the system's broken when you see a trial that goes this long. This is an abuse of everything. It's an unholy situation that's happening here. I don't know how else can I express it. I don't know. No trial should be this long.
Oh, I saw this, but Steve, is reading an Alford plea out in front of the jury?
Why would you read a plea out in front of a jury? A jury is supposed to hear the evidence in the case. That an Alford plea. Why would you have a plea in front of a jury? Why would you have a Daubert hearing in front of a jury? All that stuff, you know, like Dark Horse Production says, it's a disgrace.
Yeah. And now they did read out the Alford plea, but they forgot to. I mean, the prosecution didn't say it was an Alford plea. Because this witness had an Alford plea, and then,
and just so people know what an Alford plea is,
and then
an Alford plea means basically I deny that I did it, but I'm going to plead guilty because it's in my best interest or I don't want to fight it. So an Alford plea is basically if somebody if somebody says I didn't do it, but I'm going to plead guilty anyway, a judge will reject that plea. And so there's a lot of debate in the system of whether or not somebody can deny that they did the underlying facts and allow them to plead. So that an Alford plea is that yes, you can plead guilty even though you're denying that you actually did it. That's what an Alford plea is.
Yeah. So Mr. I don't remember his name. He had an Alford plea back in 2017. Then he pled guilty to this RICO charge, not an Alford, but acknowledging it. And Ms. Love started reading the prior Alford plea instead of the plea in this
Why?
trial.
Why?
Because the facts in that case were worse than here on the plea agreement. And
It's
it took
it's
a
just
few minutes before
it's incomprehensible to me how you can make a trial this long. And and I don't think that any trial that this long can you have. It's a jury trial. How could you ever have a jury trial that's this long that could have any kind of outcome that has any kind of resemblance to justice? Get to the freaking point.
Yeah, and there are 6 defendants with different variety of there are a combined amount of charges and 196 overt acts within the RICO charge in itself. But you have, for example, Mr. Nichols. He has 2 parts. His lawyer has asked to be severed from this trial, but denied, because how can Mr. Harvey defend his client when 95% of the evidence is not even about him?
Right, exactly. Well, they should divide this up into small little pieces and have week-long trials on each case. Freedom Ring says it's talking about a mistrial. If a mistrial is granted, it may be that it's called prejudicial against the state. So the state may not be able to bring a second case. Maybe they can, maybe they can't. I don't really care. And see, this is the point, is that, you respect the process by doing what's right. You don't look down the line and say, if I grant the mistrial, then they won't be able to try them again. I don't care. If the mistrial is warranted, grant the mistrial and let the chips fall where they may.
Yeah. And I was seeing a comment. Yeah, it was Sledge who had the Alford plea. Thank you. Monk Tonk had an Alford plea for being the driver in the 2015 shooting, which is one of the charges in this one as well, because the prosecution alleges that people in one or two of the defendants did the shooting, but they haven't actually presented any evidence, because Sledge and Woody.
I don't even know what this get to the damn point.
Yeah, and there is no point, because it's just going on and on and on and on. And for instance, when I started covering this trial, there was still in jury selection and pre-trial motions, and the statement from the Judge Glanville then at the time, this is a 6-month trial. Well, here we are, 11 months later. And I mean,
crazy.
when you're talking
It's
about
crazy. It's criminal law.
Trial, why not set a
criminal
time
law is
limit?
easy. This is not.
Yeah.
Hey, can I thank Courtney for placing an order? Courtney gave me an order, so thank you, Courtney.
Hey, nice.
Yeah, well, let's just get to it and say that any criminal case that goes this long there's a problem. Is a problem. There's a systematic problem, and it's something the judge is wrong, the prosecutors both are wrong. The prosecutor and the judge are both wrong. Anyways, I'm sorry.
No worries. Thank you to Finding Good for gifting 5 memberships. Long crime trial starting at 6:02:20-ish. Yeah, we saw it. I found it via Twitter. Thank you so much. And I mean, how can they not set a time when they are talking about 6 months, a 6-month trial in total?
I've never heard of it. This is a state court trial. It's criminal law is easy. Criminal law is simple. A prosecutor, if you've got a 6-month trial, that's insane. What in the hell are you doing for 6 months? There's no way that a criminal trial should be that long. 2 weeks, 3 weeks on the outside at most.
Yeah, and we have witnesses that Love said this will be a 3-hour witness, and that poor witness was on the stand for 3 days. And for me, this should be almost in a statute going forward, that if the prosecution claims they need 6 months, they should get half of that, and it is an absolute time limit.
Yeah, I mean, the world is laughing at us. And I would say that I guess I'm going to ask my old world friend here. I mean, what is the solution? I mean, the civil system of the continental Europe, I don't know. I mean, what's the answer here? Because obviously the system is broken here in the United States if we're allowing this kind of craziness.
Yeah. Now, if we go to the foundations of this, we have the issue with Fani Willis trying to be the RICO queen of United States and having political ambitions, going to she was aiming for Attorney General of Georgia. Now she that didn't happen now, luckily, but she did. She is the nominee for her position going forward. And I do not understand how you elect prosecutors. I don't get it. I hear the argument.
Well, and in fact,
they are being held accountable for their voters. Nobody votes.
Well, you know that the whole Soros has identified a weakness in the American system, and that is the elected prosecutor. And so, in fact, I think some of the stuff that happened here in Miami is because the hard left wants a Soros prosecutor in this jurisdiction, and so they see a conservative as being a threat to that goal. And so, this is. But Soros has identified the prosecutors, the elected prosecutors, as being a vulnerability in the American system. And he may be right. I think he's right about that. So, I don't know, because I don't know. I don't know. It's getting late. I guess I'm just getting tired, but I'm just saying.
Okay, I got a message from Blvck Law Student. They aim to get to 5K subscribers. They are at 4.36 at the moment. So if you haven't subscribed yet, here is the link. I put it in the chat. So help them reach their goal as soon as humanly possible.
Hey,
and
look at Sylvia.
Thank you to Sylvia Edwards, gifted 5 memberships. That brings us to 35 new members today. That is an amazing number. Thank you so much.
And congratulations, Nick, on what you're doing here, because following this young thug, it's not an easy job.
I mean, 80% of the time I'm having fun, because in the midst of this, I follow my grandmother's advice. If you can't do anything about it, you can always laugh about it.
But from afar, from Sweden.
Yeah.
But here, Georgia's is one state to my north. It's depressing. This is my country I'm talking about. It's not good.
Yeah, but the 20% of it is hard work, because I have this feeling of responsibility that since I went into it, I'm going to finish it, because I do believe that we who cover this trial, the people who started out a couple of years ago and the people who joined recently in covering this, we have a responsibility to see this through, because it is so utterly ridiculous that this even went to trial in this way, and how the trial is conducted, that we need to spread the awareness about this prosecutor Love. And I have said interesting words about her. I will not repeat it out of respect of Mr. Gosney, because I used very hard language and some accusations of which religion she actually might confess to. But the reason this happens is because we allow it to happen. I watched Catnot Williams' coverage earlier today when Fani Willis asked for money for doing the backlog after the big global event. And she's really convincing. And then, the aftermath of it is that money she got for doing backlog, $5 million from Atlanta taxpayers, is used for this one trial. And the reason she can do it is because people allow her to do it. Will I know that the next DA be any different? No, but don't vote for a specific. I don't care if she's Democrat or Republican, because I'm quite sure we can see the table switched on other places in the United States. I don't care because she is a bad person who should not be in this position. I don't care who replaces her, and if that person might be equally bad, then vote them out. Go time and time again. Vote. We vote every 4 years for the same reason we change diapers on kids. They will be full of shit and they need to be exchanged. Politicians and everybody who is in any kind of office. Oh. Did you? Yeah. So that is my Starovism for today. If people who are elected, sooner or later, they will be full of shit and they need to be exchanged, just like a diaper. All right. 2 hours and 40 minutes in. It's almost 5 a.m. here. I need a few hours of sleep because I do have some things to do on Saturday. This was supposed to be a Oktoberfest themed stream, but my Lederhosen didn't arrive in time, so it's just me drinking beer. At least it's somewhat German beer.
Well, I want to thank you for inviting me on and obviously being a friend from afar in Sweden, and it shows you that good people, span the world, and I'm this is my first kind of like real stream. I was on Joe of Good Logic stream, but just sort of a congratulations or sort of a large panel, but this is my first kind of long form stream back, but because you're such a nice person and a good friend and a very thoughtful friend, and also that these are important things you're covering, and I hope to get back. I'm sort of it's so hard for me I want to make sure I give everybody my best when I'm on, and I'm tired, and so this is why I'm not on, because I'm working so hard. So, but anyways, thank you for letting me come on and promote my book and all that stuff.
No worries. I will have you on anytime you can, but please take care of yourself and everything around. Yeah, and for the people who I know are watching, other people in Miami-Dade, I know who you are. I'm good at what I do. I've been doing it for a very long time. Now, Sylvia Edwards, any update on the bar complaint on Love? I have no updates on it because we don't know. I don't know if the bar complaint has been sent, because the Georgia bar does not have that officially until they have a decision. And once they have, then we know what kind of bar complaint it was and what it was about. So sadly, I have no updates. Sadly, I wish I had. I wish I could see. I wish the bar association everywhere, if there is a filing, that should be public, because these people have. It should be public, in my opinion. But then again, people might use that to, I didn't like this lawyer, let me send in something really scathing, and then it's all over the internet. So I understand why they don't. So we have to wait for a decision, and then we will see what the bar complaints actually was. But thank you, Steve, for showing up. You're always welcome. I'm glad to have you as a friend. Thank you to Rachel, who was here earlier. Thank you to Blvck Law Student, who chose to appear, and that you need to go subscribe to their channel as well. But thank you, everybody.
And great chat. You got a great chat tonight. Thank you, chat, for being kind and welcoming me back with such warm thoughts.
Yeah. Now, I did find his essay on plea documents, but I'm a bit tired. I will save that for another day. But I have it now. I will be enjoying reading it. Reading it. And yes, Law Express, free Zachariah Anderson. If you ever want to know my honest opinion about prison snitches, you go watch this part of the Zachariah Anderson trial where Munch is testifying. It's by far the least credible prison snitch I've ever seen. By far.
Yeah, it gives you a good example of why prison snitches shouldn't be used, because the whole dream, and he's such garbage.
Yeah.
In fact, I know in Death Penalty Desires, the book that I got in trouble for, I used the Zachariah Anderson crazy prison snitch as part of my trial. Birdie, if people have read that book, which nobody has, that's why they're judging it based on an article rather than actually reading the book. But if you read Death Penalty Desires, you'll see that one of the prison snitches is named Birdie Boyd, and that was taken out of the Zachariah Anderson case about she was barking out this stuff and admitted it. It's like garbage. So I put that real incident from the Zachariah Anderson garbage prison confession, and I put that in my book. So read Death Penalty Desires.
Yeah, and the prosecutor in that case, I don't remember his name, said in open court, "No, there's no deals. I am not authorized to make deals." 3 months after sentencing, Munch was a free man and moved to Florida, by the way. So he's residing in Florida now. And I've asked a couple of people to keep a notice on because the moment he screws up, gravely, the moment Munch screws up and does crimes again, I'm going to cover it, and I'm going to blame Gravely, because he let him out to do actual crimes. Because Zachariah Anderson, that trial is such a disgrace. And
Zachariah Anderson was another example of just prosecutor ego maniac, terrible process that resulted in an unjust outcome. And I don't know whether he did it or not, but I have no faith in the outcome, because that trial was an abuse of everything that the law should allow. That was a terrible prosecution, The process was fundamentally flawed, and I know that they've hired appellate counsel. I hope it gets reversed on appeal, but that Gravely guy was terrible.
And now he's retired.
Ugh.
So he got away with it, being a absolutely piss poor prosecutor for an entire career, and now he's retired with pension, government pension.
And
good one as well.
And talk about humility, it's complete arrogance. That guy was the definition of arrogance.
But
terrible,
folks, I need to catch some Zeds and feed my cat and everything. Thank you, everybody, for showing up. Thank you for the super chats, the gifted memberships. Thank you over at Rumble for the Rumble rant. And tomorrow I might have an update on the Diddy case, and maybe, depends, or if I'm just taking the weekend off this weekend. But everybody, again, thank you. I'll be sending you off to Sean, potentially criminal, who is doing something He says, why violating the FDCPA is such a big deal? I have no idea what that is, but it's if it's Sean doing it, it's interesting. Again, thank you, and sending you off with a song. Oh yeah, I use Suno.com, an AI songwriting app, and I'm having way too much fun. I will see you at the latest on Monday. Okay, folks, thank you again. And folks, hug your family. Unless your family's crap, then screw them and give your love to the people who deserve it. Bye-bye.
Adrian in the courthouse spewing fire. Every word she utters smells like a tire. Her arguments hit like a flat balloon. Manure tornado in the courtroom noon. Her voice a chainsaw cutting through the air. But the logic's missing, nothing's really there. Whirling out of circles, losing grip. Every point she makes is just a slip. Another tornado spreading wide. All her arguments turn to hide. Courtroom laughter when she's done. Prosecutor Adrian ain't one.